I have meeting it admission
For admission.
for admission.
Keep add kariye.
Because it was there in the before vacation.
Computer
Made a mention.
So I find
twice.
that around.
Yes, yes. I know difficulties will have overburden in this court.
No, not that way. But it depends on individual performance also. How far I am able to handle the load, set up a factor. So up to 3.8 actually around 450 have to be cleared already. This last listing is like
21 रे थिला.
so that it will be better to trace the file also. All memos are allowed. Actually, that is how. Since I am not restricting memos, it will be difficult.
Last date.
Sorry.
After
Yes. Mention कल सुविधा कौन ना 70 days order एक कौन है क्यों? बस suppose specifically adjourned है तिला date टा. से mention कल से file टा को बाहर करी की ताकि ये कर. Yes.
Supplemental list, page 1, 1 to 9.
item 5 I play 1 time.
Item
This
3.
one. এটা को करा करे पड़े. 5 टा को posting कर दियो तो.
मतलब item
We can see 20 sir.
जो पंडा.
Item 3, my lord. Lower court data is 29th June. After 1 week. Right?
ଏଟା ଆର୍ଜେଣ୍ଟ କାଇଁ କରୁଛନ୍ତି?
29 के अच्छी लोअर कोर्ट रो डेट अछि तार कंप्लेंट्स टा आसिले जाई कि एठी
वो ऑर्डर रेफर କରୁଛନ୍ତି ନା ବ୍ଲାକ୍
नहीं नहीं
what
order
you are ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି I cannot follow you. लोअर कोर्ट डेट ଅଛି ଲୋअର କୋର୍ଟ ସହ ହାଇ କୋର୍ଟ ର କଣ ସମ୍ପର୍କ ଅଛି?
नहीं हाई कोर्ट डायरेक्शन देथिला लोअर कोर्ट को ऑर्डर टा कंप्लेंट्स करिया पई
କୋଉଟା କୋଉ ଅର୍ଡର ରେ ଆପଣ ହାଇ କୋର୍ଟ ଡାଇରେକ୍ସନ ଦେଇଥିଲେ କୋଉ ଅର୍ଡର ରେଫର କରୁଛନ୍ତି?
लास्ट ऑर्डर
ତାର ଡେଟ୍ ନାହିଁ.
22/5
ୟୁଜ ଦ ପେପରଲେସ୍. ଆପଣ ଯଦି ସିରିୟଲି ଯାଇଥାନ୍ତେ ତାହେଲେ it would have been better so that we would not have wasted the time. 22/5 ଅର୍ଡର କଣ ହେଲା?
ତଳ କୋର୍ଟ डायरेक्शन ଦେଇଥିଲା ଯେ
କିଛି direction ଦିଆହେଇନି. My difficulty is that I have some difficulty in forgetting. When you say something which has not been done, I have some difficulty in forgetting. In your matter, I have not directed anything to the lower court. Court direction दिया था, को paragraph to lower court को direction दिया. So either you are forgetting or pretending. ଆପଣ ରି-ଆର୍ଗ୍ୟୁ କରିପାରିବେ. ବେଳେବେଳେ କଣ ହୁଏ ଆମେ ଆଡଜର୍ନମେଣ୍ଟ ନଉ ଆଉ ଥରେ ଆର୍ଗ୍ୟୁ କରୁ. ମୋର ପ୍ରୋବ୍ଲେମ ହେଲା ଆଇ ଏମ୍ ଅନଏବଲ୍ ଟୁ ଫରଗେଟ୍. ସୋ ଆପଣ ରି-ଆର୍ଗ୍ୟୁ କଲା ବେଳକୁ ଗୋଟେ କୋଉ ଡାଇରେକ୍ସନ ଦିଆଯାଇଥିଲା ତ ଲୋ କୋର୍ଟ ଡାଇରେକ୍ସନ ଦିଆଯାଇଥିଲା.
ତାର ପରେ ଦିଆଯାଇଛି
ହଁ ପଢନ୍ତୁ କଣ ଡାଇରେକ୍ସନ ଦିଆଯାଇଥିଲା ଲୋ କୋର୍ଟ କୁ.
ऑब्जेक्ट रजिस्टर को
ରେଜିଷ୍ଟ୍ରି ହେଉଛି ଲୋଅର କୋର୍ଟ.
नहीं नहीं
नहीं
कॉपी ऑफ दी सॉरी कॉपी ऑफ दिस ऑर्डर को साल फॉरवर्ड
ଟିକେ ପଢନ୍ତୁ ପୁରା ଅର୍ଡରଟା ପଢିଲେ 22/5 ଅର୍ଡରଟା କୋଉଟା ଅର୍ଡର ଆପଣଙ୍କ ଲୋଅର କୋର୍ଟ କୁ ହେଇଥିଲା. अरे कौन स्क्रोल କରୁଛନ୍ତି 3ଟା ପାରା ସ୍କ୍ରୋଲ କରୁଛନ୍ତି 3 ମିନିଟ ଲାଗୁଛି. You must understand you are taking out of turn item 3. वाइस फैन से ऑर्डर अपन कितना कोई पढ़िया पे माय लॉर्ड
ऑप्शन ऑर्डर डेट पास बाय 25 26 and 21
ठीक है यू आर इन दिस मैटर प्लीज रिलैक्स. अरे आपण निजे पे पढंतु यू आर सबमिटिंग इन ए कोर्ट. मुझे आपनकर नॉलेज पे पढ़ो आपण यू बेस दैट ऑर्डर 22/5 ऑर्डर
हमरो सेतिर दिया इता 3 लाख
पढ़ंतु आपण मते ओडिया इंटरप्रेट करा पे मुको ओडिया जाननी स्टेट अवे रीड दैट ऑर्डर प्लेस इट डोंट टेस्ट माय पेशेंस सर because I am indulgent so you will go on testing my patience पढ़ंतु 22/5
डायरेक्शन नहीं
पढ़ु नांती डायरेक्शन नहीं
petition paragraph 4 the petition has been closed
again one ru पढ़ंतु if you are forgetful or pretending so you have to read it pursuant to orders passed आपण सेटा काहे एते तोर हातरे स्क्रॉल करछन आपण तो पढू नांती
25 26
हां
and 21 5 26
और 22/5 पढ़ंतु pursuant to the orders passed in
Pursuant to order passed on 25 26 and 21 5 26 Long counsel for the petitioner submit that the petitioner is present in the court is indicated by the
indicated लिखा है
inspired by the
he is identified और आपण कोन आउट पेज खोललेडी ना एआई रे सेटा एडिट हे कि भूलभाल हे गलन
the
affidavit dated 22/5/23 filed by the petitioner पढंतु
I read the petitioner wherein the petitioner has stated
sir you are just wasting time तीन पढू आपण करिवे one question yes item 1 Mr. पाणी रे
The petitioner challenged the final order passed in a proceeding on section 125 shall be similar.
yes
The impugned order is at annexure 1 page 12 miller.
yes please
By the impugned order, the petitioner has been directed to pay 15,000 per month to the petitioner. Considering his past income, because the petitioner was earlier.
pleadings देखंदु what was your written statement कोन स्टैंड नहीं थिले
My lord,
नाही सेटा इतरे
that I have not filed, my lord.
Had so Bhavani Shankar Panigray for the petitioner, opposite party blank. The petitioner is the husband in the marriage. He challenges the judgment dated 4/8/2025, passed by the Lord Judge Family Court Keonjhar in CRLP number 41 of 2020. The said CRL.P. was filed by the wife in the marriage under section 125 of CRPC into brackets since repealed and substituted by perimeter provision under section contained in section 144 of CRPC BNSS close bracket close. Claiming maintenance, monthly maintenance. The marriage between the parties were solemnized on 24/1/2018. The opposite party wife alleged lack of maintenance and other torture inflicted on her, as well as dowry demand. While awarding the amount, the Learned Trial Court has, the Learned Family Court has taken note of the income of the petitioner to be 11,000. Sorry, 1,10,000 per month working in the IT company. The opposite party wife had claimed rupees 45,000 as maintenance. However, the Learned Court has directed payment of rupees monthly maintenance of rupees 15,000. It is submitted by the Learned Counsel for the petitioner that petitioner's past income was considered by the court while awarding the maintenance. The Learned Counsel was requested to place the written statement of the petitioner as well as the evidence adduced regarding his income stuff. He submits that he will obtain instruction stuff. In view of the judgment rendered by the Honorable Apex Court in Rajneesh versus Neha, the amount directed to be paid towards monthly maintenance is akin to a money decree. The total amount due
For 10 months, now it is 1,50,000.
Date of application,
No, my lord, it is from the date of order.
illegal order. ଆପଣ ଯେତେବେଳେ ଆସିଲେ ଆପଣ ଆସିଛନ୍ତି ବୋଲି କଣ ଅର୍ଡରଟା ହେଇଯିବ from the date of order? ଯଦି ଗୋଟେ ଭୁଲ କରିବେ, how can I even when I am citing
Because the interim maintenance was granted in that proceeding.
ସେଟା deduct ହବ.
So understood.
ଏଠି କଣ ଆଜ୍ଞା ଏଇଟା କେଶବାନନ୍ଦ ଭାରତୀ ଆର୍ଗୁମେଣ୍ଟ ହଉଛି? ରିସେଣ୍ଟଲି ସେଭଳି ଆର୍ଗୁମେଣ୍ଟ ହେଇଛି ଏଟା ଯୋଉ ସବରୀମାଲା କଣ ଏଥିରେ ଆଜ୍ଞା ଅଛି? ହଜବେଣ୍ଡର ଯୋଉ ଅଲ୍ଟରନେଟିଭ ଇଗୋ ଯେ ମୋର ଦବାର ନାହିଁ ସେଟା କୋର୍ଟରେ ନୁହଁ, ସେଟା ପର୍ସନାଲ ଲେଭେଲରେ ହବ। କୋର୍ଟ କଣ ଆଗ ବେଗିଂ ବାଉଲ ଧରି ଯିବେ କି?
Yes.
ଫ୍ୟାମିଲି କୋର୍ଟ ତାପରେ ହାଇକୋର୍ଟ ତାପରେ ଲୟର ଯିବେ। Though now the settled position of law is that the maintenance has to be awarded. Which high court decision the Rajneesh has followed from the date of application? Odisha High Court two decisions.
Yes.
There was a conflicting views of the High Courts. Odisha High Court said that it's from the date of application. Odisha High Court maybe there are some decisions where they say that from the date of order,
Also.
but they have followed Odisha High Court. The day it was passed, Odisha High Court order was there. And of course, Supreme Court order. Odisha High Court order is binding on the Judge Family Court Keonjhar.
Yes.
All right. The settled position, the law, the issue of the date of issue regarding from which date the amount is payable has now been settled in Rajneesh versus Neha, paragraph 18. That it is payable from the date of making of the application. Application date kun. In the present case, the application is dated 2020 रो को डेट कहबे ना 2020 धर देबे.
Exact date.
The Lord Counsel for the petitioner is not aware of the, and he submits that he is not aware of the date of filing of the application. Apparently, the application was filed in the year 2020. Starting with January 2021, the amount due till June 2026. What 40 It comes to 54 months into 15,000. Multiply cross. The petitioner has adjournment to file affidavit for entertainment of the revision application, how he will secure the amount. Stop. If any amount has already been paid, the same shall be indicated by giving the details in brief. Date of payment, amount of payment, mode of payment. The affidavit will be filed by Kudi sir na 13 sir. Kudi sir. The matter shall be listed for orders with the week commencement of this sir. Listed for fresh admission.
Interim application.
Interim application has to be rejected unless you secure. The Lord Counsel for the petitioner
I'll seek
presses the
adjournment.
application. Application seeking interim relief is apprised of the provisions contained in the Civil Procedure Code. Order 41. Rule 1 to bracket 3. Which is the wider scope? There is a purpose because you practice in that branch. Appeal is wider or revision is wider?
And the appeal is wider.
Much wider. Where the appeal is against a decree for payment of money, the appellant shall, within such time, the appellate court may allow, deposit the amount if disputed in the appeal or furnish a security in respect thereof as the court may think fit. This amendment is of 1977.
Yes. Let the interim application be liable.
Yes. For issuance of any for interference as far as interim prayer is concerned, The learned counsel for the petitioner is apprised of the provisions contained in Order 41, Rule 1 into bracket English 3. Comma. Yeah, Rule 10 and Rule 11. Rule rules କରିଦେଲେ ବି ହଉଛି plural କରିକି comma ଦେଇକି ଲେଖିଲେ ହବ sentence ଟା better ଥିବ। ISL ଆୟୋଗ ସେ ଯେତେବେଳେ ଆପଣ ପାଖକୁ ଆସୁଛନ୍ତି ଆପଣ ତାଙ୍କୁ law ଟା ଦେଖାନ୍ତୁ। That is how you are losing respect। ସେ ଆପଣଙ୍କୁ ଏଜେଣ୍ଟ ଭାବୁଛନ୍ତି। ସେ ତ କହୁଛନ୍ତି ଆଜ୍ଞା ମୋର ଦବାର ନାହିଁ ଆପଣ କଣ କରିବା କଥା କରନ୍ତୁ। ସେମିତି ଆପଣ କଣ କହିବେ ଆଜ୍ଞା ମୋର କରିବାର ନାହିଁ ଆପଣ ଯାହା କରିବା କଥା କରନ୍ତୁ ଯାଆନ୍ତୁ ଭିତରୁ।
ଏଥିରେ ଗ୍ରାଉଣ୍ଡ ହଉଛି since 2021 he left the job।
ସେଇଟା ଆପଣ ସେଠି କଣ କହିଲେ ଆପଣଙ୍କର
ସେଠି ମୁଁ ତାଙ୍କୁ କହିଛି
ଶୁଣନ୍ତୁ ସେଇଟା ବି it has been dealt with। ଆପଣ ଯଦି କିଛି କରିବେନି ତାହେଲେ ମୂଲ ଲାଗିକି ଚଳିବେ ଏବଂ ପୋଷିବେ ସେଟା ବି it has been settled ନା।
ଆଜ୍ଞା
ସେଟା ମୁଁ କଣ କରିବି
ଏଇଥିରେ
ଆପଣଙ୍କର ଦଲ ତ ଜଣଙ୍କ 1,10,000 ରେ ଫ୍ୟାମିଲି ଜଜ୍ କଣ ଏତେ ବି ତ ତାଙ୍କର ଷ୍ଟାଣ୍ଡାର୍ଡ ପୁଅର ସେ ତ ସିନିୟର ମୋଷ୍ଟ ଜଜ୍ ଫ୍ୟାମିଲି ଜଜ୍
1,10,000
ଇଏ ତ 1,10,000 ରେ ଆପଣ ମୂଲ ଲାଗିଲେ କେତେ ପାଇବେ ବର୍ତ୍ତମାନ 18,000 ତ ପାଇବେ 18,000 40% କେତେ 50% ହଉଛି 9,000 ସେ ଆପଣଙ୍କୁ କେତେ ଲଗେଇଛନ୍ତି 15,000 ଆପଣଙ୍କର କିଛି ନଥିଲା ସେଠି କୋର୍ଟରେ କହିଲେନି ମ୍ୟାଟର ଅଫ ଡିବେଟ୍ କମ୍ପିଟିସନ ହଉଛି
ଏଇଥିରେ ବି
ପ୍ଲିଡିଂସ୍ ତ ଦେଖି ନାହାନ୍ତି ଆପଣଙ୍କୁ ସେ ଯେତେବେଳେ ଏଇ କ୍ୱେଶ୍ଚନ ଟା କହିଲେ ଏଇ ଇସ୍ୟୁଟା ଆଜ୍ଞା ମୁଁ ତ ଚାକିରି କରିନି ମୋତେ ଦେଇଦେଲେ ଆପଣ ତ ପଚାରେ ଆଜ୍ଞା ଆପଣ କଣ ପ୍ଲିଡିଂସ୍ ନେଇଥିଲେ ଦେଖାନ୍ତୁ ଏଭିଡେନ୍ସ ଦେଖାନ୍ତୁ ତେଣୁ ସେତିକି ତ ସତଟା କହିବେ ସେ ଯୋଉଟା ଆପଣ ଦେଖିବେ ଯେ ଆଜ୍ଞା ମୁଁ ନେଇଥିଲି ଦେଖନ୍ତୁ ପ୍ଲି ତାକୁ ମୁଁ ଏଭିଡେନ୍ସ ବି ଦେଲି ସେ କ୍ରସ୍ ଏକ୍ସାମିନ୍ କରିବେ obviously cross examination ଦେଖିବେ that is how I said that you practice in prolific practitioner in that branch of law
ଏଇଥିରେ ବି from the income of
ଆଜ୍ଞା
the
ଶୁଣନ୍ତୁ
petitioner
ଏପର୍ଯ୍ୟନ୍ତ କୌଣସି ମାନେ ହଜବାଣ୍ଡ କହିନାହାନ୍ତି ଯେ ମୁଁ ଚାକିରି କରୁଛି ସମସ୍ତେ ଚାକିରି ଛାଡି ଦଉଛନ୍ତି ରିଜାଇନ୍ କରିକି VRS ନେଇଯାଉଛନ୍ତି
ଏଥିରେ from the income of the petitioner a house has been constructed and the wife is getting 30,000 per month
that is not a matter of speech sir it is a matter of pleading
that pleading is
ଆପଣ pleading ଦେବେ evidence ଦେବେ ଯେ wife 30,000 ଟଙ୍କା ଘର ଭଡା ପାଉଛି
that pleading is there
evidence ଦେଖିବେ ଆପଣ ଶୁଣନ୍ତୁ ବର୍ତ୍ତମାନ ଯଦି ଅଛି ଦେଖାନ୍ତୁ ଦେଖୁନାହାନ୍ତି looking at your face I can tell that you have not seen them ହେଲେ ଆପଣଙ୍କର courage and confidence are different ଆପଣ ତ ସେ ଗ୍ରାଉଣ୍ଡ ନେଇଥାନ୍ତି ସେ ଗ୍ରାଉଣ୍ଡ ନେଇଛନ୍ତି ଆପଣ ପିଟିସନ sir this has in fact completely destroyed the jurisprudence maintenance jurisprudence supreme court jete bhi kale high court कहले ଆମେ कहूଛୁ ଏଇ ଯୋଉ ଏଇ ପ୍ରୋବ୍ଲେମ ପାଇଁ ହେଲା ସେ ଯଦି ଦେବେନି ତାଙ୍କ ଦେଶ ବୁଝିବେ ନା ଆପଣ ସେ ହାଇ କୋର୍ଟରେ ସମୟ ନଷ୍ଟ କରିବେ ମୁଁ ଚାକିରି ଛାଡି ଦେଇଥିଲି ଘର ଭଡା 30,000 ଟଙ୍କା ପାଉଛି ଘର ଭଡା 30,000 ହାଇ କୋର୍ଟ ମୁଁ ସପୋଜ ତାଙ୍କ ଘରେ ଭଡା ରହୁଛି ଲେଟସ୍ ଆସ୍ୟୁ ଆପଣ ମତେ କହିଲେ my lord is staying in his house where the wife is receiving 30,000 per month from my lord can I have that in my judgment then we have made it we are responsible for this and whereas CPC is glaring upon appeal re entertain kari paribeni where evidence is allowed to be considered by the appellate court revision it is not allowed even the learned counsel for the petitioner is also apprised of the decision rendered by the Hon'Ble Apex Court in Samima Faruqi versus Sahid Khan wherein the scope of interference of this court by exercising power of revision in orders passed by learned family court, more so, in cases directing payment of maintenance under 125 CRPC has been considered. Paragraphs 20 and 21 of Samima Faruqi are reproduced here. ସେଥିରେ ସମୀମା ଫାରୁକରେ ସେ କହିଲେ ମୁଁ ରିଟାୟାର କରିଗଲି ହାଇକୋର୍ଟ ଦେଇଦେଲେ 8,000 ରୁ 4,000 The Honorable Supreme Court has said it is a clear case of non-application of mind by the High Court. I cannot invite those kind of comments. से कम्यूटेड वैल्यू रो एबे गोटे चलछि कम्यूटेड नै जिवे कम्यूटेड हमर पेंशन पाउनी आगा मु किछि पाउनी आपण एते बधान्य व्यक्ति आपण वाइफ रहिचंती घर भड़ा 30,000 टका पाउचंती आपण सेटा कोर्ट को नोटिस आन परलेनी फिर आपण चाकरी पड़े जाइछि must but it should have some semblance of appeal to the common sense
ଅଛି pleadings ରେ ନେଇଛନ୍ତି but
हां सेटा जदी प्रूव करथिबे कोन करथिबे हेतिबो देखो yes next
Item two,
the Lakshman Pradhan
Sir, maintenance under section 144(1). What has granted 10,000, 3,000 for son and 7,000 for wife. From by the order dated 15/1/26, Annex 5. And directed to pay from the date of filing, that is 6 September 24. I please that by the annexure 4, my lord, his annual
এটা
income.
ঠিক এভিডেন্স এটা রিট নো ডোন্ট মিক্স আপ রিট আর রিভিজন আপন সেটি কোন এভিডেন্স দেইতলে দেখান
I should add given the assets and liabilities, that is annex.
প্লিডিংস দেখান তো
Please give page 6 grounds is stated.
প্লিডিংস রিটেন স্টেটমেন্ট
Yes, well, annex 2.
ଆପଣ କୋଉ କେସ୍ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି 102
Well,
102
page 20 annex 2.
102 of 2026
It 144 1 BNSS.
ଆପଣଙ୍କର କେସ୍ ନମ୍ବର ଯୋଉଟା ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି 102 ତ
My lord. Page 20,
ଟିକେ ଆମର ଫାଇଲ ରେ ବ୍ରିଫ ରେ ପ୍ରୋବ୍ଲେମ ଅଛି ସେଟା ଚେକ୍ କରୁଛି
page 20, my lord, the annex 2. That is so cause.
ଏଟା ଖୋଲନ୍ତୁ ସାର୍ ଗୋଟେ ଦେଖାନ୍ତୁ ସେ ପେଜ ସେଟା କ୍ଲିକ୍ କରନ୍ତୁ ଆଜ୍ଞା ଆନେକ୍ସର 1 କି ଆନେକ୍ସର 3 କ୍ଲିକ୍ କରି ଦେଖାନ୍ତୁ ସାର୍ ସ୍କ୍ରୋଲ କଲେ କଣ
I will rectify that.
ଆପଣ କୋର୍ଟ ବ୍ରିଫ କାଢନ୍ତୁ କୋର୍ଟ ବ୍ରିଫ ଟା କାଢନ୍ତୁ ଦେଖନ୍ତୁ ପେଜ 65 ଠିକ ଅଛି ସେ ଖୋଜନ୍ତୁ ଯାହା ଭୁଲ ଭାଲ ଅଛି ଦେଖିବା ପେଜ 65 ଦେଖନ୍ତୁ ଲାଷ୍ଟ ପେଜ ଅଫ ଜଜମେଣ୍ଟ
My
अब एग्जिबिट लिस्ट देखो
lord.
नो
Annex 2.
ठीक है देखो आपण म्यूटेड हेले केमते हो सर
Hello?
आपण कोन एग्जिबिट करथले देखो एग्जिबिट ए कोन
Exhibit the photocopy of the statement under 161.
एग्जिबिट बी कोन
P the certified copy of the deposition PW1.
आर्नेक्सर 4 कोन
Is it that income certificate in assets
सेटा को एग्जिबिट
exhibit नाइ किंतु
assets
assets
केमते हो आपण पर बतन कहली जे सुप्रीम कोर्ट कहले नॉन एप्लीकेशन ऑफ माइंड
no assets and liability affidavit that was given.
तितु कोन मिलियो
That is a part
आपण
of
एग्जिबिट मार्क करथले कि सेटा पार्ट कोन असेट्स एंड लायबिलिटी रे को पैराग्राफ रे अछि इनकम सर्टिफिकेट लगा Mr. Pradhan, you are too senior and
Ma'am.
youngsters are watching.
my lord,
By the evening, they have these questions in mind. That what is happening in court.
my lord.
Even if I am subtle, I will not say, but it is my duty to tell you that
Ma'am.
what is happening.
My lord.
You cannot do this. Hand on it, counsel for the petitioner. He submits that income tax. Sorry, I will look to the petitioner before this court is the husband in the marriage. In fact, your next generation has come. And in a revision application, so I'm impressed. So I'll start deciding matters by entertaining annexer, not exhibited. कौन लिखना? Husband in the marriage, he challenges. The judgment dated 15/1/2026 passed by the Learned Judge Family Court dash English to Bhubaneswar. The petition was filed. Bhubaneswar in CR criminal proceeding dakili. In criminal proceeding number 245/2024.
6 September 24.
देखिए पूरा सेंटेंस कंप्लीट है এটা আরম্ভରୁ পড়ো 6 সেপ্টেম্বর কোন
Date of filing.
ରୁହନ୍ତୁ 15/1 ଠିକ ଅଛି ମୁଁ ଭାବିଲି ଆପଣ ଜଜମେଣ୍ଟ ଡେଟ୍ କହୁଛନ୍ତି ମୁଁ ଡଟ୍ କି
No, no,
ଭେରିଫାଇ
6 September, date of filing. Much.
ସେ ବହୁତ ଆଗକୁ ଅଛି କଣ ଲେଖି Number 245/2024, the said criminal proceeding was filed by the wife in the marriage and the minor child born from the wedlock. Seeking monthly maintenance under section 144 into bracket 1 of the Bharatiya Nagarika Suraksha Sahita 2023. Stop. Claim कितने थिला?
My claim 30,000.
दिल्ली रे भी से फाइल करछि मेंटेनेंस
My
दिल्ली जो आपण रोचन सेठी मेंटेनेंस फाइल हिची
no.
कारण 125 जी नहीं से फाइल करि परिबे Most likely because of your family at Delhi, you are spending a lot of money there. So that is how you have become ruined.
No, no. That is,
Upon Judah Kave gospel truth, others Judah Kave said blatant false.
that is her version.
So it is obviously it is to be disbelieved. Did you examine her?
Oh,
Then who will be, how you can disbelieve her? You are under a bounden duty to examine her. पचारथिले
take a cross-examine corner.
आज्ञा
Examine corner.
ମୁଁ ବିଶ୍ୱାସ କରିବି because ମୋ personal knowledge ସେ ଘର ଭଡ଼ା ଭଳିଆ ମୁଁ ଜାଣିଛି କି ନା ଜାଣିନି sir you are a lawyer sir that is the difference ସେ ଯିଏ ଯାହା କହିବେ ଆପଣ ସେଟା ଆସି କୋର୍ଟରେ କହିବେ ଯଦି କହିଲେ ତାଙ୍କ ଭର୍ସନ ସେଟା କହିବେ କ୍ରସ୍ ଏକ୍ସାମିନ୍ କର ପଚାର ତାଙ୍କୁ ପଢନ୍ତୁ 6.4
My
para 6.4 टा पढ़ो
judgment.
of course page 50
My On the other hand, neither the OP nor his land
Learned amicus.
well,
Yes, amicus.
amicus query having not participated in the argument, in spite of sufficient opportunity, nothing is available as argument from the side of the OP. Although PW1 has been extensively
cross-examined.
cross-examined from the side of OP, which needs to be appreciated in discussing the evidence on record, even though the pleadings of the OP cannot be
ଆଜ୍ଞା
considered.
ଯେମିତି ଆପଣଙ୍କୁ ଦିଲ୍ଲୀ କଥା କହିଲେ ଆପଣ ଛତ୍ରଭଙ୍ଗ ଦେଇ ପଳେଇଲେ ହାଇକୋର୍ଟରେ କହିଲେ ଆଜ୍ଞା ତାଙ୍କ ବର୍ଷ you have examined her extensively, did not argue, and you did the right thing, sir. You ମାନେ ଯିଏ ବି ପଚାରିଥିଲେ ସେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ୍ କଣ କହିଥାନ୍ତେ ଆପଣ ତାପରେ ଆହୁରି ଅବସ୍ଥା ଆହୁରି ଖରାପ ହେଇଥାନ୍ତା ବେଳେବେଳେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ୍ କଲେ ଅସୁବିଧା ହୁଏ ସିଜନ୍ ଯେ କାଉନସିଲ ସେ ବେଶୀ ପଚାରନ୍ତିନି नो क्वेश्चन କରି ଛାଡ଼ି ଦିଅନ୍ତି କଣ ଲେଖିଲେ This is the long and short of the story of the case. That's it. ପୁଅଟାକୁ ପାଠ ପଢାନ୍ତୁ ପୁଅର କେତେ ଖର୍ଚ୍ଚ କରୁଛନ୍ତି ପୁଅ ପାଇଁ
She got 3,000 ଦଉଥିଲା increments. ବର୍ତ୍ତମାନ କଣ ଦଉଛି
3,000 ରେ ଗାଜିଆବାଦରେ ଆପଣ ରହିବେ 6,500 ରେ ଆପଣ ଗାଜିଆବାଦରେ ଚଳି ଯାଉଛନ୍ତି The petition was favored and direction was issued. Give directing monthly maintenance of rupees 7,000 to the wife and rupees 3,000 to the son. ପୂର୍ବଟା ଆପଣ ନେଇଛନ୍ତି dictation ତାପରେ ଲେଖିବେ in view of the judgment rendered in Rajneesh versus Neha पूरा कंप्लीट करो तापर से जहां लिखा है सब कंप्लीट करो order 40 rule to rule 1-3 तापर 3A 10 11 तापर असला शमीमा फारूकी versus शाहिद खान affidavit केबे देबे
3 star.
20 ना 13 20 affidavit सेम सेट पूरा समान कर ठीक है let us be uniform at least
अच्छा दिल्लीରୁ ଆସିବ ତ
ମୁଁ ଆଜ୍ଞା 20 ଯାଏଁ ଟାଇମ ଦେବି ସେ ଦିଲ୍ଲୀରୁ ଆସିବେ କି ଦୁବାଇରୁ ଆସିବେ ତାଙ୍କ ଚଏସ୍ obviously they are not listening to lawyers କଣ କରାଯିବ These matrimonial and family matters is a difficult situation. The learned, I would line add kari, the learned counsel for the petitioner relies on Annexer 4 as annexed to the RPMM application, that is copy of income certificate, which is dated 7/4/2022. The perusal of the judgment indicates that the said certificate was not part of the record as it was not marked as exhibit. Reliance of such documents in the revision application is contrary to the principles of law laid down in Samima Supra. Yes, next.
Item
Yes,
3.
Mr. Naik. देखिले ऑर्डर गुड़ाक देखिले you could gather your thought कौन कहବାକୁ ଚାହୁଁଛନ୍ତି
19/6 को ତଳକୋଟର ଡେଟଟା ଫିକ୍ସ ଅଛି ମୋର ରେଜିଷ୍ଟର କୁ ଦିଆଯାଇଥିଲା ଯେ ତଳକୋଟ
ତା ସାଙ୍ଗରେ ସେଟା ଏଠି ମତେ କାହିଁ କହୁଛନ୍ତି ମୁଁ ବୁଝି ପାରୁନି ସେତେବେଳଠୁ ଆଇ ଏମ୍ ଷ୍ଟ୍ରଗଲିଂ ବଟ୍ ଆଇ ୱିଲ୍ ଡୁ 19 ଥର ଯଦି ତଳକୋଟରେ ଅଛି
again.
You want adjournment?
My lord.
तो तासे 1900 रे कौन संपर्क?
नहीं 29 को डेथ है.
The counsel for the petitioner seeks adjournment. So deny for the petitioner seeks adjournment. Earlier, the matter has been extensively heard on 1/5/2026. 22/5/2026. The order dated 22/5/2026 has been communicated to the Lord Judge Family Court. Stop. It is submitted by the Lord Counsel for the petitioner that he needs instructions from the petitioner. Stop. Accordingly, the matter is adjourned to be listed for fresh admission in the week commencing 27/7/2026. The status of the execution case shall be obtained from the Lord Judge Family Court, Barampur. Execution proceeding by the registry by 22/7/2026. Yes. Correction. The office note put up by the registry indicates that typographical error has crept into the order sheet inasmuch as the order dated 22/5/2026 has been mentioned to be order number 4. कितने बार?
22/5
21/5 है ना 22/5 मुझे अवतरे कहले
सर ଏଇଥର ହେଇଯାଇଛି paragraph 5 ଜାଗାରେ 4
कहले लिखो तो और सेटेस्टा पढ़ो ऑफिस नोट पुट अप बाय द कासो कोन होचे पड़ो जो जोड़ा पढ़ी पड़न तो कासो हे जाउछ ना ऑफिस नोट पुट अप बाय द रजिस्ट्री indicates that order dated 22/5/2026 where the paragraph number 4 has been typed twice. The paragraph after paragraph 4 shall be numbered as paragraph 5. Necessary corrections shall be carried out in accordance with the rules. Yes, next.
item 4
Yes, please, Mr. Suryakanta Dwivedi.
Says
for
that,
the
my-
petitioner.
Says that
Opposite party blank. Yes. Mr. S.S. Das.
my
Please.
petitioner is the husband, my lord. Challenge the expect a judgment dated 28/2/26.
Order sheet देखा तो expert कूद दिन हेले challenge करथिले कि नहीं को order expert हेले
My lord, that is
सब कोन एबे माने कोर्ट कोठी अपन जेतले challenge करछंती straight away come to the point where the court has erred.
my lord.
That is your job.
Page 46, para 3, my lord.
26 para
Page 46, my lord.
RPFM 147 तो 56.
Filed this focus, my lord, written statement, but
For expert, first of all, have you examined the matter in that way? Did you ask the person that when you were set ex parte, which order, what was the prior order, then whether he has challenged that order,
no, not challenge.
then you have participated.
Not challenge that
You must understand limitations also.
My-
You must understand what is the proposition of law. That is what you are. That is how you are a lawyer
My-
in the exalted position. 26 मुझे पाऊ नहीं आपण आज कोन
Page 46, my lord.
अच्छा जोड़ा आकर भूल अछि सेट जोड़ा तो कोई लक्ष्मण प्रधान का
Annexure 4, page.
1 second. I'm sorry. Please take your seat. I would have been briefed up पूरा भूल ही आइटम 2 रे लिखंतु मिस्टर प्रधान पढेले त इन्फॉर्म कर देबे अच्छा जानि चले आगो फास्ट लिखिबे द लॉर्ड काउंसिल फॉर द पिटिशनर सबमिट्स दैट due to inadvertence annexure 2 has not been filed though marked as annexure. The matter shall be placed before the registrar judicial, who shall obtain a report from the concerned superintendent as well as the dealing assistant how the matter without the annexure could be filed and not noticed by the SR, and accordingly the matter has been scanned and provided. Accordingly, the brief has been scanned without the annexure. এটা গোটে কাম করন্তু এটা গোটে সেপারেট অর্ডর করতে বুঝপারলে নম্বর করিকি অলগা পেজ রে করে দেবে লেটার সেটা কোন লেটার মিন্স গোটে অর্ডর এটা তো পিটিশনর কিছু কনসর্ন নাই না এটা আপনার ইন্টারনাল দেখিବାକୁ পড়িବ ଆମକୁ ଆପଣ ଗୋଟେ କାମ କଲେ ଏଟାକୁ ଯଦି ସେଇଟା ଅର୍ଡର 1 କଲେ ଏଟାକୁ 2 କରିଦେବି ସେଥିରେ ଆଡ୍ କରିଦିଅନ୍ତୁ. The learned counsel for the petitioner submits that he shall take steps for removal of the defect in not filing of the annexure 2. Annexure 2 अपन देखले पर नहीं नहीं annexure 2 to the application. सेटा पारा 1 कर देले सेटा तापर लिखो पारा 1 जो लिखले the prayer is allowed the petitioner the defect shall be removed within 7 days 7 working days.
Annexure 4 page 46.
About 26 कहले मते 26 सुविला.
Annexure 4
All of
page
us have heard 26 that is why I am not getting it. 46 yes please.
para 3 my lord. The opposite party after receiving notice appeared in this case and filed his show cause.
आपण ऑर्डर सीट रे मु आपण जजमेंट देखलेनी मते को ऑर्डर रे से एक्सपर्टी हेथिले से पे पचली I will looked into that aspect.
My lord, it is written my lord by order dated 12/1/26.
12/1/26 जजमेंट के बेला
28/2 दे अछि.
so after that you have been set experty आपण नॉन अपेरेंस कोन हेतु आपण चेक एग्जामिन करे पड़े.
My lord, the leg
this
fracture.
is not experty order आपण कोन तापरे गोवा महाप्रसाद पठेबे ना कोन
There is a leg fracture my lord. I have annexed the
अरे लेग फ्रैक्चर ता ट्रायल कोर्ट होबो ना हाई कोर्ट केमते आसले इन फ्लाइट लेग फ्रैक्चर पर हाई कोर्ट आसले ना नहीं.
my lord. That should have been my
if
lord.
you must understand if I
My lord.
accept your contention I have to record that. Is it not ridiculous?
My lord, that should have been mentioned before.
But leg fracture ता कोठी होबो आपण
That should have been mentioned before the trial court.
mentioned or whatever आपण लेग फ्रैक्चर ता जहां भी आपण प्ली नेबे फॉल्स और ट्रू सेठी नेबे ना हाई कोर्ट रे एटी अपील रे कहबे जे रिवीजन रे
My lord.
आपण लेग फ्रैक्चर वकील कोन हेतला
Amber ne see
लॉस ऑफ माइंड.
petitioner itself my lord.
अरे आपण माने आपण को क्लाइंट
My lord.
ताको वकील जे सेठी थिले ताकर कोन लॉस ऑफ माइंड हे गेला ना कोन लेग फ्रैक्चर प्ली काई नउतले एती बुद्धि नहीं. आपण जो दिन फाइल कले तापरे पार्टिसिपेट कलेनी आ लेग फ्रैक्चर कोन प्ली नेला बेले भी भाबिबे
My lord.
सेटा डिफरेंस बिटवीन ए साधारण लोक हु डजंट अंडरस्टैंड एनीथिंग.
Page 51 my lord. 21
आपण एनीवे आपण डिपॉजिट करियो जदी सिक्योर करिवे आर्ग्यू करंतु नले लेट अस नॉट वेस्ट टाइम सेम थिंग केते
my lord. I may be submit one thing my lord. 10,000
कई आपण 10 थिंग्स करंतु
10,000 to the wife and 10,000 to the child my lord. He is earning 40,000 monthly salary my lord.
40,000 तो
My lord.
हां 40% केते हो प्रॉप एस्टिमेट रे
My lord. 15 to
सेटा
20,000.
आपण आपनको प्रॉब्लम होला जे आपण अगेन सेम प्रॉब्लम दिल्ली प्रॉब्लम ताकर काजे भीतर आपनको लोकल प्रॉब्लम एग्जामिन करथिले आपण बहुत आडे पैसा खर्च करछन. That is not a ground in 125 not to give the lady and the child.
We will ready to pay my lord.
आपण रेडीनेस ता सेठी देखिबे ना एठी देखले कोन हो आपण रेडीनेस ता डिपॉजिट कर दियो तो सेठी नहीं की
से 40,000 टका कहजन से टोटल अमाउंट तार 40,000 टका पाउची. That is the difficulty.
अगे सियाडे आउरी खर्च अछि पारा 5 जो खर्चटा सेटा की बुझिबो
total salary is 40,000.
सैलरी को फिर तो से लिमिट कले हबो आपण जदी दी जगह रे घर करिवे सेपटे भी छुआ अछंती ना कोन
ना ना सेमती किछि ना, that is not the case here.
एग्जामिन कलेनी वाइफ को पचलेनी सेटा
से पार्टिसिपेट करनांती पार्ट से
आतले हाई कोर्ट कोन करिवे when where the petitioner or here the opposite party chooses not to participate in a proceeding and that he will take benefit in the revision. High Court will say that no, since you have not participated, you have to get the benefit.
some portion may be reduced, my lord, because
अरे सेटा आपण रिड्यूस करे आपण सेटा निजे कहंतु सेटा डिपॉजिट कर दियंतु रिड्यूस करी कि आई एम नॉट सेइंग दैट यू डिपॉजिट आपण सेपे तो कहले आपण जो अमाउंट कहउचंती डिपॉजिट कर दियंतु पण गोटे छोटो 2 वर्षर झियोटा
my lord, I have to pay, my lord. That is not difficult.
अरे तले आपण काई तले सेठी कहले नि काई
से total
से
amount
कहतिले आपणकर एक्चुअली यू हैव बीन इन ए डिफिकल्ट सिचुएशन
total amount देवा को से कहन 20,000 वाइफ को 20,000 छुआ को तार सैलरी हो 40,000.
ठीक
That
अछि
is
आज्ञा केते थोर बुझेबी आपण जेति की चाहउछन सेति की देकी आसत
my lord,
आपण केता देछन एफिडेविट दियो
किछि दिया इन बत I don't know, observe that I will pay.
नो आई एम नॉट ऑब्जर्विंग इट इज नॉट माय जॉब either have to become a family judge or the high court judge no in between kichi nahi I will exercise revisional jurisdiction I cannot become a family judge आपण जो प्रेयर करछन सेटा होछ आपण ओरिजिनल साइट रे आपण रिटन स्टेटमेंट रे कहिथिले कि जे मु आगे एति टका देबी
रिटिस्ट मेल को से मु 40,000 पाउच 40,000
आउची नु आपण कहि देलेनी टका सेठी जे मु एति टका एबे दउची कोर्ट वुड हैव कंसीडर्ड समथिंग rather what you are saying is usual ना किछि दवार अछि ना पार्टिसिपेट करियार अछि because you are having your relationship somewhere else आपण को लग्जरी पे आजने तो फिर सफर करूची the petitioner before the hard learned counsel for the petitioner at some length sabutre should like at some length the petitioner before this court is the husband in the marriage he challenges the judgment dated 28/2/2026 passed by the learned जो फैक्चर जो रिपोर्ट आपण फाइल कले एक्सरे डाटा कोन मु रेडियोलॉजिस्ट आपण रेडियोलॉजिस्ट तर काई फाइल करछु क्लाइंट देले त मुख पड़िबे
बोना फाइडनेस my lord.
हैं
So the bona fideness.
कोन एटा बोना फाइड एटा मालाफिडे एक्सरे प्लेट को कोर्ट रे कोन काम
There is no bad intention to avoid the proceeding, my lord.
एब्सोल्युटली बैड इंटेंशन एक्सरे डेट केबे
7/11/2025
पण एक्सपर्ट केबे हेले
12/1/2026
केमति होबो ताले when you try to cover up sir this is the problem there will be consistency आनिया बहुत कष्ट सी तार कोन वैल्यू अछि आगे तार एविडेंस वैल्यू किछि नै से कहा एक्सरे कोन हेछि ताकू के रीड करिवो आपण तो पडी कोटा फ्रैक्चर हेछि कोछन जोरा देखिले कोनटा फ्रैक्चर हेछि
the one which is at right side, my lord, probably
कोन सेटा
ankle as it visible, my lord, ankle fracture, my lord.
अंकल फ्रैक्चर कोन विजुअल नो मु तो आपण रेडियोलॉजिस्ट पळी गले दिस शुड नॉट you should not do that आपण जेडी फाइल करथांते रिकॉल फाइल करथांते
That should have been done, my lord.
एबे किछ करी होनी कोले Learned Judge Family Court Raukela in criminal proceeding number 95 of 2024 the criminal proceeding was filed by the wife in the marriage and the minor child represented through her mother guardian under section 144 of the Bharatiya BNSS 2023 seeking monthly maintenance. गोटा किसी पढ़ी ना किसी पढ़ी ना आपण तो मैनेजर अछंती मॉरिस गैरेजेस
That is their version, my lord. That is not true, my lord.
ट्रू जदि सेटा कोन एठी कहिबे भाषण देबे सेटा ना सेठी कोर्ट रे पचारिबे
It's a line.
आपण आपणकर चीफ रे कोन कहचंती तांको प्रोसीजर कोन करचन इट ऐसे कहबे मिस्टर not expected from a lawyer of your standard, Mr. A lot is expected from you.
Since he's not
आपण भाबुଛନ୍ତି ଓକିଲ ସେଟା ମିଛ କହିଦେଲେ କୋର୍ଟରେ
he is working as a line supervisor, my lord, for getting 40,000. That is the version in the so called, my lord, annexed.
ଛାଡ଼ନ୍ତୁ ଆଜ୍ଞା let's say it is better. The petition was favored 144. The petition was favored, directing monthly maintenance of 20,000 to the petitioner and rupees 20,000 to the wife and 20,000 for the child. Para 7 पढ़ो.
Para 7 of the
Para
judgment.
7 middle. The opposite party in his so cause
My lord, acknowledge that he is employed at line supervisor at Morris Garages Motors Private Limited in Vadodara, and after deduction of for taxes and PF and ESI, he receives a net salary of rupees 40,000, which he uses to support both himself and his parents. He did not reveal his actual income or the amount deducted from his salary for taxes and PF/ESI. This raises a question about the accuracy of his disclosure. my lord.
the branch you are sitting, you have chopped it off. ଆପଣ जो 40,000 ପାଉଥିଲେ କି 38,000 ପାଉଥିଲେ ସିମ୍ପଲି କୋର୍ଟରେ ଆପଣ ଫାଇଲ କରିଥାନ୍ତେ ସରଲା
So,
ଆପଣ ଗ୍ରୁପ ସି ଏମ୍ପ୍ଲୟି ଆପଣଙ୍କର ଦିସ୍ ଇଜ ଏ ରେଗୁଲେଟେଡ ଏମ୍ପ୍ଲୟମେଣ୍ଟ ଗୋଟେ ସୁପରଭାଇଜର ମୋରିସ୍ ଗ୍ୟାରେଜେସ୍ 40,000 ପାଇବ ଆପଣ କହିଲେ ଠିକ ଅଛି ହେଇଥିବ you should have proved that.
that salary slip should have been exhibited, my lord.
ତା ବି ଦେଖି ନାହାନ୍ତି ଯାଆନ୍ତୁ ଲାଷ୍ଟ ପେଜ କୁ ଲାଷ୍ଟ ପେଜ ଅଫ ଜଜମେଣ୍ଟ କୋଉଠି ଆପଣ କଣଟା ଏକ୍ଜିବିଟ୍ ମାର୍କ କରିଛନ୍ତି Before I asked you to read para 7, I had checked the exhibit. Because
Not-
basically while discussing with you, I am not against you or in favor of you. I am trying to analyze the material on record.
Nothing, my lord, because he is not participate, my lord.
कौन participate no? अपन statement written statement file करछन्ती तापर करछन्ती
WS
participate
दिया
करिनी
my lord. Exhibit.
अपन written statement file कले deny कले जे मोर दरमा 40,000 टका किंतु ताको सपोर्ट कलेनी
My lord.
So this is the only reason that you in fact there is one observation that when you do not disclose, court cannot wait for that. Court has to go by the version. Line supervisor in this check karo. Salary of line supervisor in Morris Garages. कौन है? Child. Perusal of the judgment indicates that though it is stated by the petitioner that he is earning 40,000 per month from his employment with Morris Garages Private Limited as a line supervisor at Vadodara, and his net salary is rupees 40,000. Neither did 40,000 comma to support his contention. Neither did he produce any document, nor he had stated anything before the learned court in examination in chief, or participated in the proceeding to substantiate his case. Stop. The learned counsel for the petitioner is apprised of the judgment rendered by the Honorable Apex Court in Samima Faruqi versus Sahid Khan, wherein the Honorable Court have authoritatively dealt with the scope of revision of scope of revision of judgments passed by the learned family court by this court, particularly in cases where monthly maintenance is awarded under section 125 of CRPC by family court. Stop. The learned counsel for the petitioner is also apprised of the judgment rendered in Rajneesh versus Neha at 2021 SC 569, wherein it has been observed that the amount directed to be paid as monthly maintenance is akin to a money decree. तापर CPC रा लिखी दे, like CPC the पूरा document. The petitioner has adjournment to file affidavit indicating. Let's say आपको कुछ नहीं देना है.
ना की देना.
तब good line add करूँ तो the learned counsel for the petitioner upon instruction submits that the petitioner has not paid any amount whatsoever during pendency of the petition. They say we तो देती है अपन क्या जानते हैं?
ना देना.
कि बिल्कुल interim direction भी किसी नहीं.
No.
Has not paid any amount towards maintenance during pendency of the petition. Stop. The petitioner has adjournment to file affidavit indicating how he will secure the amount directed by the judge family court towards maintenance. The due till June 2026 being 5/1/24. कोड़िए गुणन 40,000. Yes. The matter shall the affidavit be filed by कोड़िए साथ. The matter shall be listed in the week commencing. सब places आते कोड़िए 26. Yes.
Item 6.
That would go 7 lakhs per annum. Digital age रे भी आपण गोटे difficulty होची एवढा सो manipulate करिवा. कारण मॉरिस गैरेजेस रो आपण तो दामिका गाडी प्लेवन चोडू ना एबी ईवी बाहरलाणी. I'm just giving you example. आपण सीधा क्लिक कले से लिखलाणी सेतरे आ सुपरवाइजर आपण 40,000 कहबे. आपण को ग्रुप सी हेलाणी गवर्नमेंट रो 67,000 स्केल. ग्रुप सी सीनियर जो अपन डायरिस्ट से हायर लेवल रे बेगलानी. Rather, court has not gone into that aspect and has been conservative in giving the amount. देखो सेशन नियम तो कितने से देपे. Obviously, you cannot lie. Now you are aware, you are equipped with the knowledge obtained from the net. Yes, next.
Yes.
Item 6.
6.
Mr. Bhaktaranjan Barik for the petitioner.
Yes.
Mr.
Yes.
Zaninde Lekka, additional government advocate for the opposite party.
Instruction, I have received the instruction mail. Some time will be granted to file affidavit.
The learned counsel for the petitioner refers to the
Order dated 23.
order dated 23/26,
26.
wherein the learned counsel for the state had adjournment, has had adjournment to obtain instruction. The learned AG submits that he has received instruction, but the same needs to be brought on record by filing counter affidavit. Stuff. Accordingly, the counter shall be filed by
2 weeks.
24 नहीं जी 25 है 25 counter shall be filed by 15 July.
Yes.
15 July 2026 upon serving copy thereof on the learned counsel for the petitioner. The petitioner shall have the liberty to obtain instruction and file rejoinder if so advised. The matter shall be listed in the week commencing August.
No.
ସେଇଥିରେ ଆସିବ ତାହେଲେ ଆପଣ କମ ସମୟ ମିଳିବ. ଠିକ ଅଛି. week commencing 27 7
20
20 26 ହବନି.
Let's keep it 20th July.
କଣ ଆପଣ 15 ରେ ପାଇଲେ 20 ରେ ଦେଇଦେବେ ରିଜେଣ୍ଡର
Already,
ଅଲରେଡି କଣ ଆପଣ କହିବେ ଯଦି ଭଲ କଥା ଲିଷ୍ଟ 20 ଟା ଅଛି ଶୁଭ ସଂଖ୍ୟା ଅଛି ତାକୁ ବଢେ 102 କରିବାନି ଆପଣ 42 ଟା ଏଟା ହେଉ 37 ଥାଉ and I am sure ଯେ ଆପଣ 27 ରେ ବି ଆଡଜଷ୍ଟମେଣ୍ଟ ନେବେ
By that time,
ଆଜ୍ଞା କ୍ଲାଏଣ୍ଟ ଆପଣଙ୍କୁ ରେସ୍ପଣ୍ଡ କଲେ ତ
yes,
yes
seven,
Mr. Niranjan Panda for the petitioner
Please, my lord.
yes
My lord, here the order passed under order 23 rule 3 is under challenge. My lord, the suit also decreed basing on a compromise arrived between the parties outside the court. The compromise was both the parties have agreed taking 50% share each. That was also agreed. What happened? They are manipulating, and instead of distributing the share 50% each, the defendant, the plaintiff, here is the opposite party, taken 80%. Sorry, 70%. 30% comes to the side of the present petitioner. That they have manipulated.
so you are challenging the judge consent decree
Yes, consent decree under order. Yes, order 23 rule 3.
नहीं but ଆପଣଙ୍କ ଫେଭର ରେ ଆପଣ ନିଜେ କହୁଛନ୍ତି ଫେର
No, not favor.
kindly place that which part you are agree
Sir,
से जो जनरेशन ऑफ एनक्रोचर कौन हैला
sir,
जनरेशन ऑफ एनक्रोचर आपण आर्ग्यू करथिले छुट्टी रे द
ये तो
पिटिशनर इज जनरेशन ऑफ एनक्रोचर
ଆପଣ ତ ଷ୍ଟେ ଦେଲେ ଆଉ ସେ ତାପରେ ବି ସେଟା ଅପିଲରେ
तो
ଅଛି
ଚାପି ଦେଲେ
ଅପିଲ ଅଛି ସବୁଟା
ସେ ଆପଣଙ୍କର ଗୋଟେ ଆପଣ 50 ବର୍ଷ ହେଲା ରହିଲାଣି କହିଲେ ତାଙ୍କ ବୟସ 45
ନା ତା ବାପା
but you are quick enough ନା ତା ବାପା ଥିଲେ
ତା ବାପା
so that is how I have observed that the petitioners is the generation of
Sir,
encroachers from
sir,
his fathers
ସାର୍ ହିୟର
नहीं ଆପଣ ଟିକେ ସେଟା ଆପଣ ଏଟା ଗୋଟେ ବହୁତ ଡିଫିକଲ୍ଟ ପ୍ରପୋଜିସନ ଗୋଟେ ଡିଗ୍ରୀ ଆପଣ ଫେଭର ଫେର କମ୍ପ୍ରୋମାଇଜ କଣ କହୁଛନ୍ତି
ନା କମ୍ପ୍ରୋମାଇଜ କମ୍ପ୍ରୋମାଇଜ ଅଲରାଇଟ୍ वी डोंट हैव रिस्क
नहीं ଆପଣ ଯୋଉ କହୁନାହାନ୍ତି 50 50 70 30 ହେଇଗଲା କିନ୍ତୁ
ଆଜ୍ଞା।
ସେଟା ହଉଛି ସେଟା ଦେଖାନ୍ତୁ ଟିକେ
ସାର୍
କୋଉ ପର୍ସନ ଆପଣଙ୍କର
Sir,
ଜଜମେଣ୍ଟ ଅଛି କି
ଆଚ୍ଛା
ପେଜ 25
Yes.
ଏକ୍ସାକ୍ଟ ଆମର ଯୋଉଟା କି ଲୋକାଲ ଆଫିଡେଭିଟ ରେ 50% ସାର୍ ସେୟାରିଂ ରେ କରିଥିଲେ
ଯୋଉଟା କି ଆଣନ୍ତୁ
ନେକ୍ସଟ ୱାନ୍
Annex 1 sir.
ନେକ୍ସଟ ୱାନ୍ ଅଲସୋ
ଠିକ ଅଛି
ଆଜ୍ଞା।
ଆପଣ
then after manipulated
ସାର୍ କୁହନ୍ତୁ ସାର୍
पेज 35 sir, पेज 35
ଆପଣ
ଟିକେ पेज 35 sir.
ଆପଣ ଆଉ 20 ବର୍ଷ ପରେ ସାରଙ୍କ ଷ୍ଟେଚରକୁ ଆସିବେ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁ ଆଂସିୟସ୍ ହୁଅନ୍ତୁ
ଆଜ୍ଞା
ମୁଁ ଯେତେବେଳେ ସିନିୟର ମାନଙ୍କୁ କହୁଥିଲି ପ୍ରମ୍ପ୍ଟ କରୁଥିଲି କହୁଥିଲେ ବସନ୍ତୁ ଦିସ୍ ୱାଜ ଦ ଲାଙ୍ଗୁଏଜ ୟୁଜ ବାଇ ସିନିୟର ଆଉ ବେଳେ ବେଳେ ବେଶୀ ଆଂସିୟସ୍ ହେଲେ କହେ ଆଜ୍ଞା ତାଙ୍କର ଗୋଡ ତଳେ ମାଟି ଖସିଲାଣି ଆପଣ କାହିଁ ପାଟି ବ୍ୟସ୍ତ ଆପଣ ବସିଲେ ଅଦର ସାଇଡକୁ ଦେଖିକି କହୁଥିବେ ସୋ ୟେସ୍
sir,
এটা কোন পড়ি
sir 2 acres 92 decimals that
কোট পেজ
page 35 sir, page 35 2 acre 92 decimals
সাইড রে বসি যাও নান্দি
হ্যাঁ বুঝি এই বসুন
দুজন জায়গা বসি যাও
বুঝি
কোশিশ করুন পার্টিসিপেট করুন
আগে,
ভালো
আগে।
কথা
Sir, sir. 2 acres
35 না 25
page 35
35
the area and plot number everything has been stated. The total area is 2 acre 92 decimals total area. That was in favor of that plaintiff means here is the defendant and
2 acre 92 decimals
to 92 decimals in our share is 1 acre 46 decimals.
नहीं नहीं तापर पढ़ंतु ख तफसील वर्धित वृत्ति प्रतिवादी नंबर 1 गोपबंधु बेहरा
आज्ञा
बेहरांक विभाग
हाँ এটা তারপরে মৌজা ছাড়ি টবাস থানা নুয়া সোয়ানসো প্লট নম্বর 1 2 3 এরিয়া হলা 1 একর 46
बट प्रॉब्लम मिस्टर पंडा इज दैट ए जिनसटा तो आसीबोनी जलोर सिंह रे
आज्ञा
कोनकर यूजुअली कोन ए प्रकार जो थाए जे आई वाज नॉट नोटिस्ड
Okay.
फाइन दैट आई वाज नॉट नोटिस्ड
No, when there was a distribution of share, particularly, they have also distributed the share valuation of the land. सब
आपण कहउचंती 70 30 50 50
50 each.
30 हैला को स्टेज रे हैला
compromise.
एथिरे तो लिखा है जे गोपबंधु बेहरा पाइबे बोली
Compromise stage. There was a compromise arrived between the parties that basing on that compromise, each party they have already taken 50% share.
कोड सेटा अछि 50% अछि आपण तो एथिरे देखुछि जे 1 एकड़ 2
Sir, sir,
डेसिबल गोस टू
आज्ञा
गोपबंधु Gopabandhu should lead an ascetic life. Brajabandhu used to enjoy life. Mr. Ponda,
Sir.
more quick. You see, my query is very simple.
Yes.
I'm putting it a little bit differently.
Yes, sir.
If in the compromise decree, Gopabandhu has agreed for certain share
Yes.
and he has got that,
Yes.
and Brajabandhu has got for his share,
Yes.
then how Gopabandhu can come turn around and say,
No. That is
No,
there.
let me complete. Let me
Yes.
complete. So you have to show that what was the compromise
Compromise,
decree
yes.
agreed by
And how
Gopabandhu.
agreed, yes, yes.
Gopabandhu.
Sir, sir. I follow. I
Yes.
follow.
So সেই জিনিসটাকে ମୁଁ ବୁଝିପାରୁନାହିଁ।
Again. Sir, Annexer 1, page 8, sir. Annexer 1, page 8. That where the difference. Affidavit and promise one show that the ROR is wearing
problem ହଉଛି ଏଟା ଦେଖାଯାଉ। ଆପଣ କୋଉ ଜାଗାଟା ପଢୁ?
Sir. 50%. Yes. In that affidavit, sir, it is clearly stated that 1 acre 42 decimal is to come.
କୋଉ paragraph?
Paragraph, sir, page 12 ଅଛି, page 12.
Page 12.
Sir, 1.40 and a
ଆପଣ
half.
5 ରୁ ପଢନ୍ତୁ 6 ରୁ ପଢନ୍ତୁ ବେଟର।
Sir.
5 ଯାଏ ଆପଣ description ହେଲା 6 ରୁ ପଢନ୍ତୁ।
ଆଜ୍ଞା 6, sir.
That one ଆପୋଷ ବଣ୍ଟନ ପତ୍ର
ଆଜ୍ଞା।
page 10.
Sir. That one ଆପୋଷ ବନ୍ଦୋବସ୍ତ ପତ୍ର has been
ଆପଣ ବି ଦେଖି ପାରୁନାହାନ୍ତି ମୋର ଯେମିତି ମୁଁ କୋଡେ ଏଲାର୍ଜ କରିଦେଲି ବର୍ତ୍ତମାନ ହେଇଗଲା 200 100।
ଆଜ୍ଞା। That one ଆପୋଷ ବଣ୍ଟନ ପତ୍ର has been executed among us on 26/8/2019 for which the schedule land has been fallen in the share of the Brajabandhu Behera. Schedule land has been fallen in the share of the Gopabandhu Behera. From the date of Bonton Patra, we the above named deponent have been peacefully possessing the schedule lands. That we swear this affidavit to produce it before the Tahsildar mutation officer Nuaga for partition the lands under section 19(1) of the Oiler Act and issuance of the individual potta by mentioning the co-schedule land in tenant in the name of the Brajabandhu Behera and co-schedule land in the name of Gopabandhu Behera. Schedule of land. This is the schedule of land. Then so and so the it has come.
Co-schedule land रे total केते आसिला?
Co-schedule land ita 1.40. That is co-schedule land.
କୋଉ ଜାଗାରେ କହିଲେ ପାଇଲେ?
Page 12, sir.
Co-schedule land. Yes.
Sir, co-schedule. Co-schedule land also 1.41 and a half. Page 14 ଅଛି এটা।
Now next point is that ଆପଣ ଯୋଟା କହୁଛନ୍ତି ଡିକ୍ରି ରେ ଯୋଟା ଲିଷ୍ଟ ଅଛି ସେଟା ବି ଓଡିଆରେ ଅଛି actually it should have been in English.
Sir.
But anyway ତ ଓଡିଆ ପଢି ପାରୁଛୁ କିଛି ଅସୁବିଧା ନାହିଁ ସେଥିରେ ଆପଣ ଏଇ ମୌଜା ମାଇ ଛେଳି ଖାତା ନମ୍ବର 118
sir
ସେଟା ଦେଖାନ୍ତୁ ଆଉ ସେଥିରେ ଦେଖାନ୍ତୁ ମାଇ ଛେଳି 118 ସେଇ ସେମ୍ ଦେଖାନ୍ତୁ
ଆଜ୍ଞା
ନହେଲେ ଯଦି ଆଉ ଟିକେ ସମୟ ନେବେ ଏଟାକୁ ଆଉ ଦିନ ରଖି ସୋ ଦ୍ୟାଟ୍ ୟୁ କ୍ୟାନ୍
ଭଲ ହନ୍ତା ଭଲ ଟିକେ
ଆପଣଙ୍କର ଏତେ ଫ୍ୟାକ୍ଟ କହୁଛନ୍ତି ଯେ
sir ପେଜ 34 ରେ ଅଛି 118 ଟିକେ ଖାଲି 118 ଦେଖି ଦିଅ ଏଟା
34
ଆଜ୍ଞା 34 खाता नंबर 118 प्लॉट नंबर 100 these are 1 2 3 4 5 6 7 8 9 नोटा प्लॉट अछि ना बेसी अछि हां
और भी सही खाता नंबर 118
एटा मैच करनी मिस्टर पंडा
ओके
my understanding is that subject to what you will find out because I cannot in fact form a firm opinion because in fact इते कथा लेखा है ता दिहरे आपणकर आपस बंटन पत्र डेटेड सेटा पुराणाटा 19 मसियार
आज्ञा
इटे जोटा आपण फाइल करछन जस्ट लुक एट द डेट 25 मसियार some other property has been added to that बंटन पत्र
आज्ञा
so which forms part of the decree
yes
your case is that Brajabandhu and Gopabandhu have agreed. I mean, your case, man, the case as it revealed. They have agreed for settling that.
Dispute.
No, dispute settling je जो distribution था. Moja my chedi hal खाता plot number 118. ସେଇଟା 140 ଜଣ କର ଆଉ ଜଣ 140 half କି ଦି ଜଣ 140 half ପାଉଛନ୍ତି. 280 ଲକ୍ଷେ sorry 1.40 each. But ଏଥିରେ ଆପଣ ଦେଖନ୍ତୁ the area has increased not because of that particular ବଣ୍ଟନ ପତ୍ର but other plots have been added. You examine this.
Sir, ଠିକ ଅଛି. ଏଇଟା ଦେଖିଦେବ. ଗୋଟେ short date କରିଦିଅନ୍ତୁ ସେଟା କରିଦେବୁ.
Had learned counsel for the petitioner at length. The petitioner before this court challenges the upon challenge कोटा सर କରୁଛନ୍ତି
Compromise degree.
Past before the national court.
Compromise degree civil judge senior division Noyagad.
Fourth national law.
Fourth national law kadar.
The petitioner challenges the order dated 13/12/25
आगे आगे.
by the civil judge senior division Noyagad
Fourth national.
in the fourth national Lok Adalat in CS number 316/2024. In fact, that compromise decree is prior to filing of the suit. I was thinking that prior to 19 the suit was pending,
आगे.
but the suit is of 2024. Full stop. The learned counsel for the petitioner refers to the compromise decree annexed to the writ application marked as Annexure 1 dated 11/11/2019. Just one second. 11/11/2019 signed by the present petitioner as well as the opposite party, agreeing between them for distribution. Agreeing between them in the said Aposo Bantana Patra. Yeah, sentence chapter पढ़ो तो बोले लगा. नहीं, आने मोरू करो. नहीं, compromise लो. हाँ, compromise. Annexure कितने? नहीं, भूल लगा. Affidavit dated 11/11/2019 at Annexure 1. तापर कौन ले? Signed by the present petitioner and the opposite party. Which indicates agreement between the cartel, which indicates that the petitioner as well as the opposite party had entered into a compromise decree into bracket the compromise agreement into bracket Aposo Bantana Patra bracket closed. And they are in peaceful possession of the schedule of land mentioned in the affidavit. Dijon Jakara 0.78 decimal or the 1.40 point half.
आगे.
Na Jonakara 0.78, और Jonakara 1.40.
One same 1.40. वहीं करो समान.
Each of them, each of the parties to the affidavit having a share of acre 1.0. Dot 440 then 1/2 40 होते 1.40 होते decimal. Stop. The learned counsel for the learned counsel then refers to the the schedule annexed to the Annexure 2, that is final decree in original suit in civil suit number 316/2024 in the court of civil judge senior division and Odia देखुଥିଲେ सेटा कोटी
ओडिया टाइट.
and the description
Page
of
36.
property
Page 34.
mentioned in the in Odia language
Page 34.
35, 36.
indicating the share of property in favor of the petitioner Brajabandhu plaintiff petitioner plaintiff Brajabandhu Vera and the opposite party, Rupabandhu Behra. Referring to the said
The two daughters also.
it is submitted that Rajabandhu has got acre 2.92 decimal. Rupabandhu has got acre
46 decimal. 1.46
acre 1.46
46
decimals. Stop. The Lord Council for
Only, sir,
adjournment to verify the khata number, plot number, and the area, and prepare a table, preferably in English, giving the details, comparing both the affidavit dated, comparing as well as assimilating the data content in the affidavit as well as the data content in the decree.
OP number 2, 3, though have no objection. OP number 2, there are two sisters. OP number 2 and 3.
ସେମାନେ ଯୋଉ ଅବଜେକ୍ସନ ତ ପରେ ବହୁତ ଗୁଡେ କେସ୍ ଏଠି ଆସୁଛି ଆମେ ଜାଣିନଥିଲୁ ବୋଲି
କିଛି objection କିଛି କରିନା
ଆପଣ ସେଟା ଆଣନ୍ତୁ
ଆଜ୍ଞା
matter shall be listed in the week commencing କେତେ ଦିନ 2 weeks
2 weeks 2 weeks
commencing 27
27
20 ନା 27
15 sir 15
27 ठीक
27 publish
बोर्ड छुट्टी 15
publish
Hello.
to meet Mrs. Sujata Jaina, senior advocate, along with Mrs. Ponda for the petitioner. Yes, please.
Item A.
Mike, please understand.
Eight.
I'm 9.
My lord, I am challenging annexure 5. It
Yes.
is my second journey to a lawsuit's court. My lord, the husband filed a petition for restitution of conjugal right and the wife filed a petition for divorce. Both the cases were transferred to Bhubaneswar, family judge Bhubaneswar.
Yes.
And while, my lord, by virtue of the order passed by this honorable court, while passing the order, this honorable court has directed both the matter may be heard together. And
Section 9 and section 13.
so he is proceeding only on section 13, so that it will be infructuous. Section 9 will be infructuous.
I could not get.
My lord,
So
section,
he's proceeding only in section 13 means?
section 13, he is right now taking evidence so far as section 13 is concerned. But unless section 9 is taken
And how
up,
do
it will be.
how do you demonstrate that from the order sheet?
My lord, your lordship may kindly see.
So what is the let us start with the High Court order, or you are referring to earlier High Court order?
Earlier High Court order,
Not annexed.
not annexed.
But anyway, there was a direction, both the
But
cases
see,
have to be
ଗୋଟେ
tried at
ଅଛି।
Bhubaneswar.
ନାଇଁ ଆପଣ ଯୋଉଟା ଦେଇଥିଲେ ଅଛି
9 and 13 both have to be tried at
Heard
Bhubaneswar.
yes, there is no
Bhubaneswar
there.
କଣ ଫାଇଲ ହେଇଥିଲା ନା ଭୁବନେଶ୍ୱରରେ କିଛି ଫାଇଲ ହେଇନଥିଲା
ଭୁବନେଶ୍ୱରରେ ଫାଇଲ କରିଥିଲା wife for divorce
13.
yes ମୁଁ ଫାଇଲ କରିଥିଲି କଳାହାଣ୍ଡିରେ for restitution of conjugal right.
But
On
the
receipt of the
problem is
notice-
I got it
Yes.
from Kalahandi to Bhubaneswar ଆସିଲା, so then now
କିନ୍ତୁ ଗୋଟେ ଭୁବନେଶ୍ୱର ଫ୍ୟାମିଲି ଜଜ୍ 1 କୁ ଆସିଲା ଗୋଟେ 2 କୁ ଆସିଲା, so I have to file another petition.
ଗୋଟେ ଜାଗାରେ ହେଲା
ହେଲା।
ବର୍ତ୍ତମାନ ଫ୍ୟାମିଲି ଜଜ୍ 1 ହେଇଗଲା ସବୁ
Yes.
2 ହେଇଗଲା.
Yes, 1.
So how do you say that that 13 is not being 9 is not being taken up ସେଇଟା that
My
part?
lord, your lordship may kindly turn to page 26.
Yes,
that will-
26.
Para
there
3.
only.
Para 3.
Yes, para 3.
Third on the petition, peruse the material available in the present case record and also the case record in CP number so and so. There being a clear order of the Honorable High Court that the present CP number so and so being a case registered after receiving case number so and so in this court on transfer of CP number so and so pending before this court could be tried together. The petition filed from the side of the petitioner in this case for prior adjudication of the present case, then CP number so and so is not maintainable.
So that I was trying, that I was telling you. You cannot say the section 9 to be tried first and section 13 to be tried next. So while framing of the issues, since they're tried together, there will be issues pertaining to restitution.
Yes. Pertaining to
So
my,
rather para 3 is in sync with your submission.
yes.
Suppose now the wife, you are for the husband. So husband says section 9 should be tried fast, considered fast. That cannot be because it has to be tried together.
My lord, while doing so, section 9 should have been taken first in view of the fact that otherwise it will be
Once that, then you have to seek
modification.
Or challenge in Supreme Court.
No, my lord.
Because the reason being section 9 and section 13, perhaps the lawyer is under the impression. I'm sure you are not the trial lawyer.
No.
When the issues will be framed, definitely section 9 will be there.
Yes, must be. My lord,
That stage has not come.
my lord,
Because your petition is contrary
right
to
now
the...
evidence is now the parties are on evidence.
Yes.
So,
ତାପରେ ଆପଣଙ୍କର section 9 ଆଉ 13 ରେ section 9 ଆଉ 13 ରେ ଆପଣ ଯଦି witness ଦେଖିବେ ସମାନ ହବ. I mean same witnesses. 9 ରେ ସିଏ ହେବେ PW, 13 ରେ same. Even ଆପଣଙ୍କର ଯଦି ground of desertion ରେ ଆପଣଙ୍କର ଥିଲା cruelty. Suppose, let us assume. Let us assume whatever ground.
Again.
ସେଥିରେ ଯା written statement ସେଟା ବି section 9 ରେ ସେ consider
It's
କରିବେ.
also applicable, yes. But my submission before
ତାପରେ
you,
4 ଦେଖନ୍ତୁ.
para 4. Accordingly, the petition stands rejected, being devoid of merit, put up the present case with CP number so and so for recording of the evidence of PW1. In that case, for trying together, henceforth, in compliance of the order of the Honorable High
So
Court.
again,
My lord, again,
3 and 4 is in sync with what your submission
my
is.
lord,
But perhaps the lawyer there, he is thinking that
But
9
he
should
is
be tried first.
but he is no, I'm not on that. I am not on that. My lord, my submission before your lordship is that section 9 I have also quoted. Your lordship may, otherwise it will be infructuous.
No.
If divorce will be granted, if proceeded
The
with the
problem is
divorce.
that if ifs and buts, this court cannot take note of. This court can very well take 3 and 4 note of. And 3 and 4 is absolutely in sync with your submission. Your point is well taken.
Yes.
You are saying that once the court directs for analogous or to the matter should be tried together, then one case cannot be prioritized, rather both have to be taken together.
Yes.
But the court has rejected the petition when the petition is filed that try section 9 fast, and para 4 is important actually.
Yes.
Para 4 is the consequence.
Yes.
When you are a PW1, when you are making statement, ଆପଣଙ୍କର ଏଥିରେ actually CP ରେ 672 ଟାରେ କ'ଣ ସେଇଟା that I cannot ଜଣା ପଡୁନି. 672 is for
Good.
1062 ଟା କ'ଣ 9 ନା 13?
ଆମେ ହଉଛୁ ଆଜ୍ଞା CP 904.
No, I'm not asking.
Aଜ୍ଞା.
CP 662 of 2024 is filed by wife or husband?
By the way,
Wife. For it is a 13.
or divorce.
13. So kindly mark then 4. That is favoring you. Para 4.
Yes.
Accordingly, the petition stands rejected, being devoid of any merit. Put up the present case in CP number 672 of 2024 for recording of evidence of PW1.
Yes.
In that case, for trying together henceforth, then she has to participate, give evidence in your section 9 also.
Yes. But my lord, so far as section 9 is concerned, I am the petitioner.
ଆପଣ PW ଆପଣ ଯେତେବେଳେ ଆପଣଙ୍କର ତାଙ୍କର ଯୋଉଟା ଆପଣଙ୍କର 13 ଯେତେବେଳେ ହଉଛି she is the petitioner PW1.
Yes.
And she will be DW in your application.
In my petition.
And just the court has clarified that. In that case, for trying together henceforth in compliance of the High Court order,
Yes.
the present case need not be put up separately also.
No, need not be put.
Yes.
I
Put
don't.
up together with CP number 672.
I don't ask for to put up separately.
I think the perception, it's a wrong perception.
Lawyer ଯିଏ କରୁଛନ୍ତି
ସେ ବୁଝି ପାରୁନାହାନ୍ତି.
ସିଏ କହିବା କଥା ଯେ ଆଜ୍ଞା ଆମ କେସ୍ ଉପରେ ବିଲକୁଲ ଶୁଣାଣି ହଉନି. So for which
ଆଜ୍ଞା ଆପଣ ଲୟରଙ୍କ ସ୍ପିଚ୍ ରେ ଯିବେ ନା ହାଇ କୋର୍ଟ ଅର୍ଡର ରେ ଯିବେ?
କୋର୍ଟ ଅର୍ଡର ରେ ଯିବି.
ଆପଣ ତ now you today tomorrow you will appear for that side.
Yeah, nahi.
So ସେଥିରେ କ'ଣ ଅଛି କି
Nahi,
senior
draft-
counsel କର ବର୍ତ୍ତମାନ ତ like Supreme Court they change that. So obviously we have to go by the court order. 3 and 4 are it can't be more specific than that.
May I suggest one thing?
Yes, please.
Your lordship may only give an observation, dispose of the case. That will do.
Observation, the problem
Observation
is
that-
something which is in your
Yes, observation to the
no,
effect.
I mean observation in the sense
Observation that
because there is already observation for
That is
trial
true.
together.
Yes, yes.
When one party files an application,
That
just kindly
again.
para 2টা দেখুন 2টা পড়ছিল actually better হইতান্তা 2 3 4
At
একাডি
this stage, learned amicus curiae for the petitioner in this case filed a petition praying therein to adjudicate this case under section 9 of the Hindu Marriage Act, so and so, in short, prior to the adjudication of CP number so and so.
So that has created problem.
That has created
He
problem.
should not have. Either he should have sought for modification of High Court order or challenge the High Court order. Just say,
No,
let us assume, hypothetically, let us assume that the petitioner says that no, simultaneous trial it cannot be tried together.
then I have to.
But the general principle 9 and 13 it should be tried together.
Yes,
Yes.
yes.
So Stankaraju say he has created this problem. He should not have filed this application on paragraph 2. So the court has responded in 3 and 4. If you read 3 and 4 in isolation also,
Yes,
it is
yes,
fine.
Yes.
And why did he file the application after High Court order then section 9 laga trial karantu boli?
No, earlier he filed the petition because the court proceeded in the
Apana taku
divorce.
bujhantu. He needs guidance. Apana
The-
jetebale because the trial court cannot prevent your client, I mean the husband in say pursuing section 9. Rather the court says court has taken the concept taken note of the High Court direction says that
simultaneously.
na see to apana application deichanti
Try
for
fast.
adjudication fast. That cannot be done.
My lord, the purpose is, my submission before your lordship is that the purpose of section 9 is for to be together and to save the married life. Whereas section 13 to sever the married life. So if something can come out while
Philosophically,
adjudicating section 9, that will.
Madam, philosophically you are right, but the wife files a 13. She is an independent person. Husband files
Yes,
section
but
9.
But
So whether wife should have filed or not filed, that's a different.
no,
But once it
don't
is
say-
filed, it is application.
No,
It has
I
to be
don't
taken
say,
note of.
I don't say so. My submission before your
No, I
lordship.
cannot modify my earlier order.
No,
It has
your
to be tried
lordship,
together.
your lordship cannot.
And
Because-
3 and 4 are amply clear to the extent that the court is trying together.
That
And interestingly, apana PW nuhanti 672 re. Mo setpai
Na,
I have
na.
checked it. If let us assume that jodi court koithante je that you in your case you become the PW.
evidence. I don't. Recall ହେଇଥିଲା କ'ଣ some.
Say 672 re apana hochanti defendant.
ହଁ ମୁଁ dependent, but I
So
have already been.
when
But I have
apana-
already been.
Suppose now PW1, the wife starts her evidence as PW1. She is the defendant. You ask your questions in section 9.
Section 9.
Section 9 तो अटकी नहीं ना.
Section 9.
आपनकर जो apprehension रोची आपनकर trial court lawyer करो. Section 9 अटकी गला. Section 13 चालीला. That is not for based on record.
No, but in the meantime, some evidence has been taken. May I suggest your
आपने
lordship?
use करो तो से.
हाँ, नहीं, your lordship may keep it to Monday.
रखो तो but I think
Let me verify what has happened.
the thing is that this
Your lordship,
your apprehension should be assuaged by the observations of the court in paragraph 2, 3 and 4.
Yes.
2 maybe 2 because you have asked for prior hearing
Prior
of 9. Court cannot because High Court has directed simultaneously. And even if section 9 and 13 they have to be had together, that's a general principle.
9 and 32.
Because that is in your interest. That is in your interest. आपनकर wife पर allegation कौन cruelty. आप cruelty रे आपनकर 9 रे आपनकर defense.
Desertion and cruelty.
Whatever.
Desertion
रे
and cruelty.
आपनकर section 9 रे होबो जे desertion. You have not deserted. She has deserted, and you have not been cruel. That is your defense in section 13.
Desertion has to be proven in different manner also. Whether it has been done within 2 years. If it has been
We
filed.
must discipline.
So if
Animus descendendi should be there.
animus this should be.
ଜଣେ ଯାଇକି ଅଲଗା ଜାଗାରେ ଚାକିରି କରିଛି ତାକୁ କହିବେ ସେ ଡେଜର୍ଟ କରି ପଳେଇଲା
ନାଇଁ ସେଇଟା କିନ୍ତୁ ଏଠି
So
ଦି
ସେଇଟା
ଜଣ ଯାକ
anyway
no whatever my lord
ଆପଣ ଖଣ୍ଡେକୁ ଆସୁ ଠିକ ଅଛି
your lordship may
The
keep
matter
it.
shall be listed on had the Lord Senior Counsel for the Ajiro Adita Lekhuntu. The Lord Senior Counsel for the petitioner is had at some length. It is submitted that though this court has directed for both the CP number 672 of 2024 before the Lord Judge Family Court dash English 2, Roman 2, Bhubaneswar, under section 13(1) into bracket 1 of the Hindu Marriage Act for dissolution of marriage and CP number
904
of
25.
25 filed registered on transfer from the Learned Judge Family Court Kalahandi into bracket CP number 12 of 2024 bracket closed under section 9 of the Hindu Marriage Act should be taken up together. The Learned Judge Family Court 2 is proceeding in taking up the application filed by the wife under section 13(1) prior to the application under section 9 of the Hindu Marriage Act is considered. It is submitted that the direction of this court of taking up both the matters simultaneously, both the matters to be tried together. Language is tried together.
Tried
together is not achieved. Stop. By order dated 24/4/2026, in an application filed in CP number 904 of 2025 by the present petitioner, who is the petitioner before the Learned Judge Family Court in the section 9 application. The following has been observed, paragraph 2, 3 and 4. The result of the observations of the Learned Judge Family Court in paragraph 3 and 4 would indicate that the Learned Judge Family Court by the said order dated 24/4/2026 has directed the matters to be tried together in compliance of the order of this court. In view of the observations of the Learned Judge Family Court, the petitioner need not be apprehensive that the section 9 application will not be taken up together. Monday ko rakhiwa. The Learned Counsel for at this stage, the Learned Senior Counsel submit six accommodation to obtain up-to-date instruction. The matter shall be listed in the week commencing
27 sir.
27
7
ସେ ଗୋସିଏ ଭୁଲ କହିଦେଲେ ଆଜି ଆମେ
27
ଆଜି କେତେ ତାରିଖ
24
ଆଜି
ବନ୍ଦ ହଉଛି 29/6 ଆପଣ ଏଇ ଯୋଉ ଏପଟ ସେପଟକୁ ଜୁନ ଏପଟକୁ ଜୁଲାଇ ରଖନ୍ତୁ
29
29/6 ଆପଣ କଣ ସ୍ପେସିଫିକ ଡେଟ୍ ଚାହୁଁଛନ୍ତି 29/6
ନା
ଆସୁ ଆଡଜଷ୍ଟ କରେ କାରଣ 29/6 ରେ ଆକ୍ଚୁଆଲି ରହିଯାଇଛି
ଇ କମେନ୍ସିଂ କରି
127 ଟା ମ୍ୟାଟର ଅଛି
ଇ କମେନ୍ସିଂ
shall be listed for fresh admission ହେଲା
ଓବ୍ଲେସ୍
I think ଆପଣ ଯୋଉ କ୍ଲାରିଫିକେସନ ଚାହୁଁଥିଲେ ମୁଁ ଅଲରେଡି କରିସାରିଲି
ମୁଁ ଟିକେ ଦେଖିଦିଏ
କିନ୍ତୁ ପ୍ରୋବ୍ଲେମ ହଉଛି ଯେ ଥରେ ଗୋଟେ କୋର୍ଟ ଯଦି ଠିକ ଅର୍ଡର କରିଛି we should encourage the court rather than finding fault for nothing.
No.
ଆପଣ ଗୋଟେ ଆପ୍ଲିକେସନ ଦେଲେ ସେଟା ରିଜେକ୍ଟ ହେଇଗଲା ଠିକ ଅଛି there you are right but the reasons are ମାନେ well reasoned ଯେ କୋର୍ଟ ହାଇକୋର୍ଟ କହିଛନ୍ତି simultaneous trial ହବ ତାଙ୍କରେ ସେ PW1 ଆସନ୍ତୁ ଏଭିଡେନ୍ସ ଦିଅନ୍ତୁ ଆପଣ that opportunity you should avail. Rather, I think the trial court lawyer, what he is thinking, perhaps, he being the dominus litis in section 9, see open kariya katha.
Dominus.
Kintu, apana jehetu trial together habo, wife asile evidence daba pai. Apana section 9 kahibe. Setebele jodi court apana allow karibeni, then of course the court has not. Rather, I mean, you have not been treated equally by the court. because you will not get that opportunity
Yeah,
again.
opportunity.
ସିଏ ଯେତେବେଳକୁ ଆସିଲେ ଆପଣ ତାଙ୍କୁ ସେକ୍ସନ 9 ରେ ଏକ୍ସାମିନ କରିଦିଅନ୍ତୁ।
ମୁଁ ସେଇ ବିଷୟରେ
ଆପଣଙ୍କର ଯେତେବେଳେ ସେକ୍ସନ 13 ରେ ସରି ଆପଣଙ୍କର 9 ରେ ଆପଣ ଯେତେବେଳେ ଏକ୍ସାମିନ ସେଇଟା ଆପଣ ଡିସାଇଡ କରିପାରିବେ ଆପଣ 9 ଟା ପରେ କରିବେ କି ଆଗ କରିବେ ଏକ୍ସାମିନେସନ ପାର୍ଟ ରେ ସେଇ ପାର୍ଟ ଟା ଟିକେ ବୋଧେ ପ୍ରୋବ୍ଲେମ ହଉଛି। I think that is
Section
creating the
13
impression. That is creating the impression on the lawyer that ମୁଁ କରିପାରୁନି କେସ୍।
ସେକ୍ସନ 13 ଟା ଆଗ ଚାଲିଛି ସୋ ସିଏ 13
ନାଇଁ,
ରେ
ଆପଣ 9 ଟା ତାଙ୍କୁ ପଚାରିବେ ନା
ପଚାରେ ସେ ତାଙ୍କୁ ଆଲାଉ କରୁନାହାନ୍ତି ସେଇଥିରେ
ସେ ଅର୍ଡର ଟା ଆଣିବାକୁ ପଡିବ। But court is very conscious. Para 3-4 ରେ ସେ court rejected your application to take up the matter ahead of 13.
Ahead
That is
of
there.
that is there.
Yes. Next.
Let me verify my
Yes.
Okay.
Yes. Next.
Item 9.
Yes.
Also, I have poor lady belonging to the economic weaker section. I have applied for the ration card. That is not being considered. And your lordship may see annexure 1, page 9. In the digital auto inclusion process, my remarks has been yes. Page 9.
ଆପଣଙ୍କର fact finding authority ରେ ସବୁବେଳେ always try to go to the fact finding authority. ଏଇ ଯୋଉ ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି this order is not to be appellable କି higher authority ପାଖକୁ କିଛି ନାହିଁ।
दिया है lordship. Annexure 2 series रे सब total authority को representation दिया है।
Representation ନୁହଁ ଆଜ୍ଞା representation ଅଲଗା representation ହଉଛି ପତ୍ରାଚାର appeal ଆଉ revision ଏଗୁଡା ହଉଛି ଅଲଗା ଜିନିଷ ଏଠି statutory ଆପଣ that is the difference between ପତ୍ର ଲେଖିବା ଏବଂ appeal କରିବା you are a lawyer କ୍ଲାସ ଲେଖିବେ ପତ୍ର ଜଣେଇଥିବାରୁ ତ୍ରୁଟି ମାର୍ଜନା କରିବେ appeal ରେ କଣ ସେଟା କରିବେ appeal ଆପଣ ଫାଇଟ୍ କରିବେ କୋଉ ଅର୍ଡର ଆପଣ ଆଗ୍ରି
Lordship,
ଆପଣ ଯୋଉ ଅର୍ଡରଟା ଆଗ୍ରି ସେଟା ଦେଖାନ୍ତୁ
annexure 2 series, your lordship. My acknowledgement received is annexure 1. And
It's not, no such order has been passed in.
it is totally not being considered, your lordship.
କେମିତି ସେଇଟା sir is there a presumption ଯଦି presumption ଥିବ ସେଟା ବି ତ କହିବେ ଯେ there is a presumption how the court will think that ଏଟା ହେଇଛି କି ହେଇନି either way
I'll take instruction.
instruction न ପଡା କିଛି ବାଟ ନାହିଁ ସାର୍ ଙ୍କ ପାଖରେ କିଛି information ନାହିଁ ତ ସଞ୍ଜୟ କୁମାର ପାଣିଗ୍ରାହୀ for the petitioner you are Mr. ପାଣିଗ୍ରାହୀ
SK Panigrai, your lordship.
Sanjay Kumar Panikar for the petition, Mr. D.N. Lekka, AGA for the opposite party. It is submitted by the learned counsel for the petitioner that the petitioner, though entitled and deserving to receive ration card
Ration card.
within single court, she has not been issued any ration card after she has made the application.
Application, representation.
Application annexed to the writ application marked as annexure 1 dated 27/11/2025. On being asked how the petitioner knows that she has not been, her case has not been considered. The learned counsel for the petitioner submits that she has no instruction to that effect. However, the petitioner has made representation dated 18/4/26 to the authorities. And annexed to the writ application marked as annexure 2 series stuff. The learned AGA shall obtain instruction from the appropriate authority. The matter shall be listed for fresh admission in the week commencing 27/7. The Pradhan, the Vishnu Prasad Pradhan for the petitioner. Yes.
Item 10.
Yes.
Expiry order of maintenance passed by the land judge family court. Against that, not present petitioner has preferred application under section 145(2) proviso. That application is pending before the land judge family court to set aside the order of expert judgment. During pendence of that application, the wife and daughter proceeded with execution proceeding. In that execution proceeding, present petitioner set expiry. On the very same day, I filed an application to set aside the expiry order. Land judge allowed my application, but imposed 2,40,000 as a cost. Now I am not quarreling with that order. I am not quarreling with that order. I am prepared to pay the entire amount, whatever amount land judge has passed an order. But that amount should be kept in a fixed deposit account. Why I'm saying, my lord? Because both are the stranger to me. Opinion number 2 and
125 ରେ ହବନି
are stranger to me.
ହେଇପାରେ 125 stranger order has been confirmed by the fixed
Well, that's right.
So
But
the problem is
only difficult is
the problem is that any kind of relationship 125 ରେ ହବନି ସେଟା ଏଇଟା ଆପଣଙ୍କର ଆପଣ actually ସେଟାକୁ that is called that suit is just mone put maybe article पर mone
125 order will sustain or not, it will be decided in my application.
stranger fixed deposit ସେଟା କରି ହବନି 125 ର जो evolution as it has happened any kind of relationship without somebody without being a wife as you say quote unquote or a husband can claim.
Look, I am not disputing that. I am not disputing. But why difficult is, for example, I will make deposit of 2,40,000. Wife and daughter will take back that amount. How will recover if the court will find they are not the
125 court cannot give the finding. That I have suggested that is my proposition to you. 125 court, if he starts investigating that whether she is a stranger or the daughter is a stranger in your life, that opportunity is not there for the 125. Apana court declaratory suit says suit.
The suit I have filed. That suit is pending for declaring the
That's the justification. That justification suit has to be there. 125 रे हबनी. And what I am saying that the stranger argument in one matter. So he is capable. He carried it to the Supreme Court. I said I will interfere after you deposit. Supreme Court has confirmed that. My order that directing that you secure the amount. That rather you should deposit that 2.5 there. Let them have for this time and future you may not. But if you 125 jurisdiction, I mean that concept.
No,
is
difficult or I will make deposit. He will withdraw with an undertaking. If will not succeed, he will return back. That is the only.
How the destitution will be the 125 concept is to prevent destitution and vagrancy. Justice Krishna. So that has gradually evolved to different kind of relationship. Now it has been interpreted whether the person is related or not, whether the person is wife or husband or not, because 125 can be filed by a husband also. That the court cannot, the magistrate is not to investigate. Long-standing cohabitation is enough.
Yes, that is not her case also. If my lord will examine that, that is not her case. Because in
that case of Sambalpur, the person said that I am married to somebody, I have a child, this lady is a stranger.
Any kind of relationship.
No.
My lord has already expressed any kind of relation sufficient for one.
No, I am not.
I am not disputing that.
I am not. No, that has evolved. The CRP, the 125 has been and you see, it is across the religion also.
Yes.
You find Samima Faruqi, Justice Deepak Mister judgment. So and you find in 125 domestic violence. Domestic violence is still expanded because it uses the word financial assistance.
Yes, that word is
final. The evolution section 12 is not maintenance also. It says assistance. So I mean other genders also can avail domestic violence. So that is how it is very difficult. It is better after you pay, you get some relief from the court.
I am prepared to pay. I am not disputing that. Even though my right heart will be transplanted, that I am not going to that area because I am in bedridden now.
You deposit, you take instruction, you deposit that amount for the time being, then you can have some reprieve for the future.
That I will obtain. That I will obtain.
Now the problem is that once you ask your client again upon deposit karantu, he will go and engage Mr. D.N. Lenka.
Correct.
Correct. That is the problem.
I'll obtain instruction that.
Sita chalibo tapare fishing expedition. See kebe asibe, kebe case hobo, it goes on. The rest of the matters after recess. Order document. I'll dictate the order after.
Well,
so the same.
I will not be there. My associates will be there because I have some.
Item 10,
27
27 साथ है ना earlier? ठीक है, 27 ठीक है. Pradhan for the petitioner, top opposite party blank. The learned counsel for the petitioner is heard at some length. The petitioner challenges the order dated 22/25, 7/6/25, 26/8/25 and 28/26 passed by the learned judge family court Bhubaneswar in criminal execution case number 98 of 2024 arising out of CRP number 220 of 2019. Number देखिए लिखी हुई है, date and number. The CRP 220222019 was filed by the opposite party and opposite parties. Opposite party number 2, being minor, represented through her mother, through his mother guardian. Under section 125 of the CRPC, into bracket, since repealed and substituted by perimeteria provision contained in section 144 of the BNSS 2023 bracket closed. In the petition, it was stated that the marriage between the petition number 1 and the present petitioner and the OP number 1 was solemnized on 21/2/2007. The child is born from the wedlock. The petitioner did not cross-examine the plaintiff's witnesses to put his own case in the cross-examination. The Lord Judge Family Court relied on the marriage invitation card, joint wedding photograph of petitioner number 1. Joint wedding photograph of the present petitioner and of OP number 1. To arrive at a conclusion that the present petitioner and the opposite OP number 1 are married to each other. The petitioner is working as district education, petitioner was then working as district education officer, Malkanagiri. Stop. The Lord Judge Family Court directed for payment of rupees 8,000 monthly maintenance to the OP number 1 and rupees 6,000 to the OP number 2 in the present petition. Perusal of the judgment indicates that the present petitioner did not examine any witness in the said proceeding, nor marked any exhibits supporting his case. Stop. Thereafter, the execution, the judgment and decree was judgment and order was put to execution, out of which the present application arises. CPC provision order 47 rule 1(3) the court conjured act the court. Then Rajneesh versus Neha, then Samima Faruqi versus Sahid Khan. The learned counsel, the petitioner has adjustment to file affidavit indicating how he will secure the decree for the executing court. But before this court, public the affidavit stop. The affidavit shall also indicate the amount of maintenance paid till date, giving the details such as date of payment, amount of payment, and mode of payment after the judgment dated 19/5/2024. The matter shall be listed in the week commencing 27/7/2024. Yes, next.
11.
Pardon your lordship.
Yes, please.
I appear on the behalf of my senior Mr. Sambit Mahanti.
Yes.
I pray for an adjournment on this matter.
Your name, madam?
Sarita Mishra.
Ms. Sarita Misra on behalf of Sambit Mahanti for the petitioner. The petition being listed for fresh admission is adjournment is sought for on behalf of the petitioner. Adjournment is sought for in absence of the learned arguing counsel. The matter shall be listed for fresh admission in the week commencing
20/7.
20/7/2024.
12,
May I please?
So Maheshwar Mahanti for the petitioner. Legit party blank. Yes.
Now here, before I starting the case, my lord, I have filed an application 10169 for grant of leave. It is a partition decree of Permanent Lok Adalat where we are the legal heirs are not been made parties. Only one son imputed father as party, and they admit that this is ancestral property, but we are not made parties. So I challenge their order, decree, and consequential error.
Kindly show the petition before the learned trial court.
We are not the parties.
Kindly show that.
My lord, kindly come to page 15.
Yes.
Paresh Mandal is the plaintiff, who is the present OP number 1. And
How you are related to
Where-
sorry, Chittaranjan Mandal?
who are the wife, sons, and daughters.
ଦେଖନ୍ତୁ IA 10169 of 2026 and WPC number 18334 of 2026.
Aye.
The petitioners in the writ application challenge the order dated 15/2/2025 into bracket annexure 5 and the final decree dated 15/2/2025 into bracket annexure 6 in P and C case number 58 of 2025 passed by the learned judge permanent and continuous Lok Adalat Kendrapada under section 21 of the Legal Services Authorities Act 1987. Mutation टाको आपण एथरे केम चैलेंज करिवे
सर आवार्ड कन्सिक्वेंशियल पार्ट भी चैलेंज करियो सर गोटे ऑर्डर हो गला ऑर्डर टा भूल ऑर्डर बळे तांका नार पुनी एरर हो गला सेटा अनेक्सर 7 सीरीज
म्यूटेशन टारे जीट
Mutation
चैलेंज
है।
करिवे दैट्स द क्वेश्चन यू हैव टू आंसर
ना सर ए जो अनेक्सर
ना सर
अनेक्सर
आपण हो सर कहबे ना आपण रीट रे म्यूटेशन आरवार टा चैलेंज करछु
ना कन्सिक्वेंशियल
सो
पार्ट
रीट पिटिशन रे को जुरिसडिक्शन अछि म्यूटेशन आरवार कंसीडर करे
ना सर कंटीन्यूअस कॉज ऑफ एक्शन कोन गोटे जजमेंट है
आपण मते बहुत जिंस मु जानिनी आपण मते जणे परिबे किंतु जोटा मु जानिनी पचारती सेटा आगो जणांतु
सर म्यूटेशन पे म्यूटेशन अपील इज देयर
हां मु सेटा केमते
आई एडमिट
एडमिशन कथा नहीं एथरे एडमिशन कोन अछि कि मु मना कर नाय नाय म्यूटेशन अपील थाउ पछे मोर इशू करबे नोटिस
से कोन
मोर कथा हला जे अंडर व्हिच जुरिसडिक्शन आई कैन एक्सरसाइज 226 एंड इंटरफेयर इन ए म्यूटेशन आरआर अरे तहसीलदार ऊपर अछनी सब कलेक्टर एडीएम ऊपर कलेक्टर चीफ सेक्रेटरी किए अछंती सेटा आउट हायरार्की मु गोटे अलगा जगह रे अछि
सर 5 and 6 टा होची रीड जुरिडिक्शन आछी
हु
Annexure 5 is judgment, Annexure 6 is decree passed by Parliament.
सुनिलेनी कि ऑर्डर डाक
Sir, sir. किंतु Annexure 7 series
आपण चैलेंज करूचंती
Annexure 7 series टा होची effect of Annexure 5 and 6.
कि मना कला
Sir,
Who says no
sir, Annexure 5
I think either you are deliberately not answering or
No, sir, ମୁଁ କହୁଛି appeal is maintainable. Mutation manual
so because
Annexure 7
you see
series
as such which judgment governs this permanent Lok Adalat
2008 Supreme Court
कौन
State of Punjab versus
जलोर सिंह
Balvinder Singh.
बलविंदर नो जलोर
That is a State of Punjab versus Research Coach. Punjab versus Jalor Singh.
बलविंदर तो कहीं कोचन
Sir, वो पार्टी Balvinder.
ठीक है so
Sir, Annexure 7 series
so
टा है.
problem is that mutation error cannot be challenged by जलोर सिंह
Sir, I had.
अरे एडमिट करले कथा नहीं आपण एडमिशन करे कथा you have created a legal issue ना problem
सर ମୁଁ ସେ ପାର୍ଟଟା ମୋର
ଆପଣଙ୍କର ମାନେ once the Lok Adalat order goes then that consequences will follow
आगे
obviously
आगे
कौन लेकिन yes तो full stop कर दियो apart from challenging the आपण माने you are sleeping जो mutation हैला के दिन लागेला mutation आ
सर हमको नोटिस हैनी
mutation है notice हैला
हमको नोटिस
Apart from challenging the above orders, the petitioner also challenges the record of right pursuant to mutation. Mutation number कितने?
The mutation number 1 is 466 of 26, page 30.
Huh?
Two
30.
mutation cases, my lord. One is
In mutation
465,
cases.
465 26
465 of 2026
and 466 of 26.
466 of 2026 order कहीं
Order no arrow at the
order challenge का error challenge करी होगा सेटा भी जानी नहीं
sir, I will file order. Certificate of order.
सर्टिफिकेट का अपन चैलेंज करे सर्टिफिकेट को फाइल कले आई छिबो सेटा सेट by filing a certificate copy in High Court the order will be
No,
set
sir, I will file amendment.
anyway
Right.
all like नहीं सेटा से करी ना सेटा मु ताको इंप्रूव कर देबी and apart from challenging so and so the petitioner also challenges the record of rights annexed to the writ application marked as annexure 7
7 series.
at this stage on being asked at this stage the Lord Counsel for the petitioner was apprised of the fact that the petitioners have not challenged the orders passed in mutation case number 466 of 2026 and mutation case number 205 of 600. 2020
number.
466 of 2026 as well as mutation case number 465 of 2026. The Lord Counsel is also apprised that for challenging a order passed by the revenue authority in a mutation case, writ jurisdiction is not the appropriate remedy, as the Odisha Survey Settlement Act provides the remedy. Stop. In response, it is submitted by the Lord Counsel for the petitioner that due to inadvertence, the mutation case orders have not been challenged in the writ application, which are consequence of the order passed by the permanent Lok Adalat. Stop. It is submitted that the present petitioners, कौन से?
Present petitioners.
Petitioner number 1 is the wife of the.
आगे. OP note 2.
से थिले कौन थिले? सेठी कौन थिले?
सिटी सर पार्टी नथिला बा?
पार्टी नथिले हे गला ऑर्डर
सर देखुना पेज
अरे सर टिके सुनिबे सब पड़े अपन जो प्री ऑक्युपाइड है कि गोटिए कथा को भाबिबे हबन
सर पेज 15 टाइप आसन मु सर कहि
अपन बिल्कुल कोंतनी मु निजे निजे करी दरकार कोन लिखले His wife of the opposite party in the suit CP number P&C case number 58 of 2025, page 25, not 50. You can see a case number. Hello. 15 ने भी सेटा अच्छा तो से तो अच्छा थी opposite party. अब तू कौन कोई?
सर वो सर मो रीड पिटिशन ने जो
पिटिशन मोड डिक्टेशन दउची
नहीं सर सोल opposite party
who is the wife of the opposite party in the P&C case number 58 of 2025. The plaintiff, the petitioner in the P&C case is one of the sons of the opposite party who has been added as OP number
1.
2 in the OP number 2, Chittaranjan 2, who has been added as OP number 2 in the present writ application. The petitioner in the P&C case is added as OP number 1 in the writ application. It is submitted that the present petitioner number 1, apart from present petitioner number 1 being the wife of the OP number 2 in the writ application, the other petitioners are
sons
and daughters of the OP number 2, who is the opposite party in the P&C case. It is submitted that the present writ petitioners and the necessary parties in the necessary and proper parties, those should have been implemented as the P&C case involved co-property. Ancestral property, self-acquired property.
Ancestral property, agricultural land and Gharabari.
Ancestral property, agricultural land and Gharabari. They submitted that the rights of the petitioners towards it is submitted that property rights of the petitioners have been infringed without they being heard or repleted in the proceeding before the P&C, permanent and continuous local adalat. Para. In view of the issue regarding the petitioners not being implemented and heard, in considered view of this court, the issue raised is covered by the decision rendered by the Honorable Apex Court in State of Punjab versus Jalor Singh stuff. Issue notice to the opposite parties by speed post with restriction. Issue notice to the opposite parties along with this order with speed post and registration and proof of delivery. Requisites for issuance of notice be filed within 5 working days. Returnable date be fixed to 27/8/2026. The matter shall be listed in the week commencing 10/8/2026. Regarding the challenge to the record of rights in the writ application, as observed above, the issue is kept open. Stop. आइए रे जोटा फाइल करना है कि से जो
Leave.
अपन ऊपर जोड़ा लिखिଛନ୍ତି कोन लिखले इशू नोटिस इन द आईए as well as the writ petition जोटा ऐड करते हैं along with this order. हेडिंग टा तो दिट जाक अछि तब एटा इशू नोटिस से इंक्लूड हे गेला आईए 10101001 of 2026. Hard nodded counsel for the petitioner, he reiterates his submissions as noted above. Issue notice as above, accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. Stop in the interim. There shall be stay of operation of the order tag.
Paid for status quo.
There shall be stay of operation of the cook order tag.
Next year 5.
Order dated 15/2/2025. Passed by the Court of the Judge Permanent and Continuous Local Kendrapada in P&C case number 58 of 2025 until further orders. Status quo as on date regarding the properties mentioned in
schedule.
In schedule of
IA 10101.
In the schedule of IA 101, लिखी देवे. Which page देखते?
Page 3.
Status quo with regard to right, title, interest, possession, ownership, nature, character. With regard to the properties mentioned in the schedule of so and so, देखिए. Page टा कहाँ पे आता है?
Page 3.
Page 3 of IA 10101.
I.
Shall be maintained by the parties.
Right.
आपन possession रे अछंती?
A joint possession of ancestral.
अछंती joint possession. Yes.
Sir, से 15/2/20 डकायला 15/2/25 हो. So order track.
ऐसे देखिए लिखिए.
Annexure 5 सेटा 15/2/25. Set.
ठीक है एआई छोड़ा एनआई भी अप्लाई करिया पड़ो. एनआई कोन कहले? निजो इंटेलिजेंस. सबुठी आर्टिफिशियल इंटेलिजेंस कल सिलेक्शन पर
अर्जेंट कर.
यस.
13.
Urgent certified copy as per please.
My lord, that kindly takes time to.
In Mr. Pramod Kumar, you are Mr. Sahoo, Mr. Pramod Kumar Sahu for the petitioner. The learned counsel for the petitioner seeks adjournment to advance arguments according to the matter shall be listed in the week commencing.
Odisha.
27 26.
14.
Yes, please.
Discuss my lord, I have a difficult care for the direction to the High Court cut my lord. On speedy disposal of my lord, and the number of two petition number that is CP number.
Speedy disposal has been dealt with by the Honorable Apex Court. In which matter? The High Court cannot pass such orders. Have you examined?
Maybe to submit by a very unfortunate scenario.
Unfortunate. Apart from stating the unfortunate scenario, you have to read the constitutional bench decision. Which decision? So I'll pass an order. I usually pass.
My lord, since last 10 years, my lord.
It can be 10 years, 100 years. That's not the discussion. Suppose.
2 months, my lord.
So any matter older than 10 years is pending.
My lord, this is my lord.
Arey, taro answer kimti my lord hobo. In the court, Lorded Judge Family Court cut up. If any other matter is pending more than 10 years, that the Supreme Court has, Honorable Apex Court has flagged. Because somebody comes to High Court, it is very unfortunate. Unfortunately, the matter is pending for 10 years. Then whether High Court can issue a direction for disposal, that the Apex Court has dealt with.
My lord, in the marriage of 2 months, my lord, wife deserted. Or taking away all the.
Can that be a ground where
10 years, my lord.
where the wife deserts the husband after 2 months, then there has to be expeditious trial.
Be old in any parents.
Can that be a ground for expeditious disposal? Lordship has to consider. Lordships have considered already. That cannot be. That.
They refused to come, my lord.
Your lack of preparation is apparent. Your lack of preparation is apparent. So I cannot pass an order contrary to the Honorable Apex Court order on the face of it. And the next matter, the Honorable Apex Court has observed that the High Court, what the High Court should not do, is doing every day. What the High Court did, exactly what you are telling the High Court to do. For pendency of 10 years, desertion of wife within 2 months, cannot be a ground for expeditious disposal. So have you filed any application? So you are attributing the delay to whom?
Wife is
Delaying. So have you filed any petition? Because CPC is very clear. When the wife is the opposite party.
Section 9 petition was there. She refused to come.
You can only understand by listening, not by speaking. Have you filed an application invoking CPC that when the wife is taking time? Did you file an application?
My lord,
where is that? So that.
My lord, it is the 5 times there was consolation. And she refused to come.
Consolation cannot be a ground for expeditious decision.
Yes, my lord, she entered with some hooligans, my lord, in the month of April, my lord, and there was my lord crying inside the house of the. Five times
failure of conciliation and entering with hooligans cannot be a ground for expeditious disposal. No, I'm passing some order, but same order I will pass. Yes, disposed of. The expeditious disposal to touch. Yes. Yes.
15.
So Pratyashis Mohanty for the petitioner.
I'm appealing for the
Naik, additional standing counsel for the opposite party. Yes, Mr. Mohanty.
I'm challenging Annexion 9. It's basically a dispute between one society registered under the Society Registration Act and another trade union. Was the contention of the society? I'm appearing for the 73 members of the society who has been denied to get a registration, re-registration, which as per the mandate of the society's regulation is required. Yearly registration of truck enrollment.
Kindly place the order.
Lordship,
Which part you are agreed?
Lordship, and Annexion 9, your Lordship, page, I'll just briefly I submit what the
the opposite party number 8 in this.
Instead of summarizing that, you straight away place from the record.
Lordship, it's the observation and decision, Your Lordship, at page number 106.
Yes.
Upon perusal of all documents placed before the ADM Kalinganagar, it is ascertained that both associations are separately registered entities and are functioning independently on different occasions. They are taking different shares for Vaishnagar municipality and Korei area separately. It is a matter of fact that once a member is separated from one parent association and joined another rival association, such member cannot simultaneously continue as a member of both the associations. Lordship, what has happened?
No, I didn't ask you to explain this. You did further, completely.
Yeah. Accordingly, it is hereby ordered to maintain the law and order situations. Both the associations shall henceforth function independently, peacefully, and with their respective registered members. Membership shall be determined on the basis of registration of records, and therefore members registered under the Vaishnagar Truck Owners Association need not have their vehicles renewed under the Jaspur Road Truck Owners Association, as both the association have registration papers. Regarding all other allegations, he had held that it is not within my jurisdiction.
Can you read?
Regarding the allegation of irregularity, corruption, illegal activities, and non-conduct of general body meeting, the ADM Kanina has no jurisdiction to adjudicate upon such matters, as both associations are registered on a separate registering authority. Accordingly, the concerned parties may approach the appropriate registering authority if they have any grievance needs to be redressed. Both the associations are hereby directed to maintain peace and tranquility.
Which part you are agreeing?
Your Lordship, the part where they have denied me registering my vehicles with the society, Your Lordship. What is?
Sir, means state in abstract. They have denied me with the vehicle. Which registration? Which vehicle?
Your Lordship, that is what I'm coming.
So kindly
Your Lordship. And Your Lordship,
what
may have
been denied me?
Lordship, Your Lordship, have a glance at Annexure 5 series, Your Lordship.
No, from the order, sir, not Annexure 5 series.
Lordship,
Which part of the order, since you are challenging an
Lordship.
administrative order,
Lordship.
more the reason you have to show the flow from the order itself.
Lordship. Your Lordship,
Which line you are, or which part you are agreed by?
The first part where it contended that I have been these petitioners have been is a separate rival association, which is not, because it is a trade union and another is a society.
What was your stand? What is your stand before the ADM? So that
Lordship, that
the
is
submissions have been recorded.
Your Lordship.
So from your submissions recorded by the ADM.
Lordship, it is at
You are for Jajpur or you are for Vaishnagar?
Vaishnagar, Your Lordship.
Okay, so that.
Lordship. Let's say page 105, para 2.
Better you use the larger one, the larger Wacom, so that will be easier for you. Because after I reach page 105, after a few seconds you are reaching there. So, it I use korna.
In contrary to the submission of the Jaspur Road Truck Owners Association, the Vaishnagar Truck Owners Association submitted the following. The amendment made to the bylaws of the Jaspur Road Truck Owners Association was carried out improperly in the guise of renewal of the association. According to them, only the bylaws were amended and several illegal activities are allegedly being carried out by the said association. They further allege that the Jaspur Road Truck Owner Association is collecting ₹20 per challan for truck owners for permitting loading operation in Sukinda mining region, thereby causing harassment to the truck owners. To avoid such.
So what you are now stating, it is not mentioned
Lordship,
in the ADM's order. Kindly show from your statement what you contended.
Lordship, the last one, to avoid such issues, they stated that the Vaishnagar Truck Owner Association is directly issuing challans to
trade union, different union, all those things.
Lordship.
Submission re nahi.
Lordship.
So, copy file karchanti ki?
No.
Statement.
Got a representation, Your Lordship, I filed.
Representation
No, Your Lordship, on basis of the
adjudication and representation.
On basis
what you are stating now before
Lordship.
this court.
Exactly.
This court wants to see what was your stand there.
The entire proceeding that has been initiated is the basis of that particular representation submitted by me, Your Lordship.
No.
That is at Annexure 8, Your Lordship.
You have to show what you are stating that they are a trade union, you are a truck owner association, all those facts where you have stated.
Your Lordship, that is at Annexure 8, Your Lordship. Annexure 8 is my grievance petition. On basis of this grievance petition, this entire proceeding has initiated. Even in the commencing paragraph also, it has been mentioned. Of the order in the order, it has been mentioned.
Annexure 9 doesn't refer to 5222026.
Lordship, there is
straight away go to Annexure page 104.
Lordship, however, the Vaishnagar Truck Owner Association had raised a grievance that the Jaspur Road was not renewing the vehicle registration of its members in the register maintained by the Jaspur Road Truck Owner Association. Lordship.
What is the question?
Lordship had asked you whether I have raised that particular plea in my petition or not, which has been filed before the ADM.
Did we stop there? Then you said that my grievance is 522026.
Lordship.
So then I ask you that where 522026.
That has not been referred, Your Lord. That has not been referred.
Then how can I imagine?
That has been
that is your imagination, your version of your.
No, Lordship, that is the initiation of the.
Whenever a client approaches you by stating this, you should have asked this question to your client.
Lordship, that has.
How can you completely blank now?
No, Lordship. This is the document that has been given.
Sir, that cannot be stated.
Lordship.
Like you are believing the truck owner association, I have to believe the pleading.
Anyway, that has been specifically recorded in the order, Your Lordship.
It is not there.
It's the fourth paragraph.
Page 104, it doesn't refer to that representation.
I bow down to Your Lordship.
Why should you bow down? You have to say whether it refers, because you are saying that 104 annexure 9 is result of your representation dated 522026.
Lordship.
On your persuasion only, I am searching for that.
Lordship,
It's not there. Now you are saying it is.
But the contention of whatever I had read,
that is the. How do you know that you are not the ADM?
No, Lordship. I understand. Even no, that is what.
So it is the impression given by your client. So whatever they will say, he will go back and submit it.
At 104 itself, the order of the ADM, it has been mentioned that the core issue has been mentioned.
Even you have forgot the question also.
I understand, Lordship.
So then why you are not saying that?
It has not been there.
Leave it there. Nothing.
Lordship, let me file it otherwise.
Why should you? I am asking you, it is on record actually. You are saying Annexure 9 is adjudication of 522026. So I asked you that you show that Annexure 9 is adjudication of 522026. Both are there. 5226 is there, Annexure 9 is there. That you show.
I'll file the grievance petition if at all it has been filed or not. I'll place it.
One step ahead, 3 steps backward.
No, Your Lordship.
What I am saying, the grievance petition is Annexure 9.
No, Annexure 9 is the ADM's order.
I'm sorry, Annexure 8.
8, Your Lordship.
So 9 8 आपण ठीक जानी पड़ले 8 रे को 9 कह दिले 8 8. You are saying 9 is result of Annexure 8.
9 is the result of the grievance. 9 is the result of the grievance that has been raised by the
you can review the YouTube also.
No, I'm not disputing whatever my lord is saying.
Sir, what is this fun of saying, using the word dispute? Court is disputing your statement.
No, I am not disputing. That is what I'm saying. I am not disputing your lordship.
When you are saying you have to take the responsibility of, supporting
lordship. I apologize.
Nothing.
Lordship, just let me have one adjournment, lordship.
What should you?
I'll bring the petition on basis of which this.
You are already saying I have to record. But I got second innings.
No,
you are saying Annexure 9 is result of the Annexure 8.
If your lordship may peruse Annexure 9, just for a moment.
Your difficulty is that.
No, Your lordship.
You have not read. So, Annexure 9, where it refers to Annexure 8.
It doesn't refer, Your lordship.
So then.
It doesn't refer.
You are saying my lord may peruse.
No, I'm seeking a lordship's indulgence on Annexure 9 only itself. On the order of the ADM. There is a statement that has been made by ADM.
Mr. Mahanti,
lordship.
You are arguing for seeking judicial review of administrative order.
Lordship.
So you are asked that what was, because you said that this is my contention.
Right.
Then you are asked to show that what was your contention. Then you did not find that. Then you say my contentions are there in Annexure 8.
Lordship.
Then the next question is that if Annexure 8 is your contention, then how the Annexure 9 doesn't refer to Annexure 8? Then you are saying that I'll find out.
What I was submitting, your lordship, at Annexure 9 in para 5 only, my entire issue has been recorded. That's only irrespective of whatever has been recorded. The only issue that I
can't be irrespective of. It's a reckless submission.
No, your lordship.
You cannot presume and put words to administrative order.
No, I'm not putting at all. I'm just submitting, your lordship. What
counsel for the petitioner? The petitioner is has stated to be a registered truck owner association, and these transporters are absolute hooligans. They're absolute hooligans. I'm not saying about you.
I understand. This is
their first thing is that, and this is a absolute. I mean, the which part you are agreed. There you started struggling actually.
This is
When,
your
when I
lordship.
asked you that which part of the order
Right.
you are aggrieved,
Right.
then you started struggling. You were maybe I
No,
don't
no.
know whether you are confused genuinely or not.
No, your lordship. The only issue that
Which part? Finally, which part
this
of
is
the order
that
you
is
are
what I'm
aggrieved at?
showing. That is what I'm showing, your lordship. See, how jo page 104 right, fifth para. However, is what start is. However, the Vasanagar Truck Association had raised a grievance.
Finding ko hala apna submission
This is
dicchonti.
this is just
Which part of the order?
a submission to deal kari the order has been passed.
Nahi, nahi.
Your lordship, I'm coming to the order.
Straight away come to 106.
106 is second para and third para.
Record that. You are mentioning 104 and rejected.
Lordship, second para and
Petitioners
third
are
para.
stated to be ଶହେ ଜଣ ହାଇକୋର୍ଟରେ ରିଟ୍ ଫାଇଲ କରିଛନ୍ତି କଣ ଜଣେ ରିପ୍ରେଜେଣ୍ଟେଟିଭ ହେଇପାରିବ
73.
ଆପଣଙ୍କର ରେଜିଷ୍ଟ୍ରେସନ ନାହିଁ
It is a study.
ବାଇଲ ନାହିଁ
All of them are
the petitioners for reasons best known to them 73 in number have stated to be a general to be member of Truck Owners Association Jajpur have approached this court on being asked why the 73 persons have approached instead of one person in representative capacity as per the bylaw. The Lorded Counsel for the petitioners has no answer, has no immediate answer. They challenge the order dated 13/5/2026 passed by the Additional District Magistrate Kalinganagar. Which is which indicates that order which indicates thus annexure 9 and this is regarding passing of orders to resolve disputes so and so up to put forth their demands. They put forth their demands no up to their submissions are as follows. Since the order dated 13/5/2026 is a administrative order by the Additional District Magistrate, the Learned Counsel for the petitioner was pointedly asked to refer to the portion of the order by which the 73 petitioners are aggrieved. He submits that. Though the petitioners are not agreed by any part. Again, finally, Mr. Mahanti, which part at page 106 you are agreed?
para 1, 2, 3, your lordship.
The petitioners are agreed by the subparagraphs 1, 2, or 3. 1, 2, subparagraphs.
First, second,
subparagraphs. We are agreed by the first, second, and third subparagraphs of the observation and decision of the Additional District Magistrate at page 106. Along with the first, second, and third paragraphs, the fourth and fifth paragraphs, which is the entire observation and decision, are reproduced herein. In considered opinion of this court, none of the observation or decision of the ADM is against the petitioner. Rather, the administrative decision is for achieving peace and tranquility in the region as observed by the administrative authority. In considered view of this court, in judicial review under Article 226 of the Constitution of India, the satisfaction of the authority cannot be looked into. The Lorded Counsel for the petitioner refers to 104 page.
104 page, fifth subpara, your lordship. Fifth paragraph.
However, however, the Basanagar,
Hi, Lordship. However, the Vasanagar truck.
Lordship counsel for the petitioner takes exception. It submits that the petitioners take exception to the fifth subpara of the order dated 13/5/2026 at Annex 9, which reads thus. However, the Basanagar Truck Owners Association up to Owners Association.
Lordship.
However, the Basinagar Truck Owners Association up to Jaspur Road Truck Owners Association. Having gone through the said paragraphs, there is nothing to show that the petitioners can be aggrieved, as it is a statement of facts alleged by the parties before the administrative authority. Certain other submissions have been made by the learned counsel for the petitioner that the opposite party truck owner association is a trade union.
No, the present petitioners have formed a trade union.
The present petitioners have formed a trade union,
due to which they have been barred to re-register their vehicles under the society.
due to which they have been barred to re-register their vehicles
Under the society.
under the society.
OP number 8.
OP number 8. Regarding the same, it is apparent upon perusal of the representation of the petitioner at Annex 8, dated 5/2/2026, was not the subject matter before the ADM. This court does not express any opinion if the petitioners can avail any remedy. Trade union re truck owner ହେଇପାରିବ ନା ନାହିଁ?
That is what I am submitting, Lordship.
Yes.
Trade union ରେ truck କେବେ ତାଙ୍କର truck owner ର business regulation, economic affairs ରେ trade union କେବେ ଦେଖିବନି. It's only the society, that particular truck owners association society.
Trade union re truck owner registered ହେଇପାରିବ ନା ନାହିଁ?
Lordship, it can.
Who provision? Trade union act.
It's regarding the.
Trade union ଆଣିଲେ? ପାଇଲେ ଆଉ ଗୋଟେ ଆକ୍ଟ ଆଣନ୍ତୁ ଆଉ ନାହିଁ ସବୁ ତ 2-3ଟା 3-3ଟା ରଖିବେ ନା ଆଉ
Lordship, the definition of trade union, if I may read.
ମୁଁ ସେଇଠି ଅଟକିକି ଅଛି
Trade union means any combination, whether.
slowly ପଢିବେ
Lordship. Trade union.
ଟ୍ରକ୍ ଓନର ଆସିବେ କି ନାହିଁ ବୁଝିପାରିବେ
Lordship. Trade union means any combination, whether temporary or permanent, formed primarily for the purpose of regulating the relations between workmen and employers, or
workmen
and employers, workmen and employers, or workmen and workmen, or between employers and employers, or for imposing restrictive condition on the conduct of any trade or business, and include any federation of 2 or more trade unions.
how a truck owner will become a truck owners will become a
Lordship, second, see your last 2 para re padibo. Employers and employers, between employers and for imposing.
Employer definition.
Lordship, it is there. T3 nahi. This act does not have the.
ये पढ़िबे तार objects and reasons.
Lordship. An act to provide for the registration of trade unions in certain respects to define the law relating to the registered trade unions, whereas it is expedient to provide for registration of trade unions, and in certain respects to define the law relating to registered trade unions, it is hereby enacted as follows.
So kindly mark 5.
Lordship.
Section 5.
Lordship. Every application for registration of a trade union shall be made to the registrar and shall be accompanied by a copy of the rules of the trade union and statement of
Which
the
register?
registrar of the trade union.
So if a registered trade union is different and the register of society is different,
Lordship.
how do you say that they are interchangeably can be made?
I'm not saying that, Lordship.
Then who is saying? I am saying.
My pleading, Your
You are
Lordship.
saying that since the court the opposite party is you are a trade union.
We
You
are
a trade
also
union.
we are also a member of the trade union. And my submission is that all the petitioners, 73 petitioners, are also a member of a trade union. They're also the member of the society under which is a OP8. What has happened? As they formed the trade union, now as the society they were the member of the society and their trucks were also registered on the society. Now,
A trade union member is a animate or inanimate object?
it is a different individual. Trade union has a different.
Question is very simple.
Not
Members of a trade union is animate or inanimate?
animated.
So how a truck will be animate?
No, that is what I'm saying.
That's the problem. You are registering trucks.
If your lordship, lordship may see my prayer, your lordship.
So your prayer. Answer the query.
Lordship.
My question has to be answered instead of looking at your prayer.
Lordship.
You are saying that since you have part of the trade union, formed a trade union.
Lordship.
So the trucks are not registered under your
Trade union. Lordship.
So how it can be done?
But
It doesn't appeal to common sense.
No,
Then what about other objects? If trucks can be. So suppose let us assume owner of a chair.
Yes.
I will form a trade union along with Mr. Nayak, Mr. Mahanti, because we all have chairs. We have all got chairs. Let us be very specific.
That is my
chairs.
lordship. That is my humble submission, lordship. But
You are just thinking off the cuff and standing on your feet. You are saying so many.
No,
things.
lordship. It's
So
just because I have formed.
Anyway, that doesn't support.
No, lordship.
Since you have said.
Just by one submission.
ଆପଣ କଣ ଚାହୁଁଛନ୍ତି ଯେ ଟ୍ରେଡ୍ ୟୁନିୟନ ରେ ଟ୍ରକ୍ ମାନେ ରେଜିଷ୍ଟର ହେବେ?
No, lordship. I am seeking my ମୋର ଯୋଉ society ରେ ଯୋଉ registered ଥିଲା truck ସେମାନେ ମତେ allow କରିନାହାନ୍ତି re-register କରିବା ପାଇଁ. That is why I wanted.
ଆପଣ ଟ୍ରେଡ୍ ୟୁନିୟନ ଅଛନ୍ତି ବୋଲି?
Lordship, that is the one.
କରିବା କଥା ନୁହଁ, ଠିକ କରିଛନ୍ତି।
Because the lordship
society ରେ ଆପଣଙ୍କର ଯଦି society registration act ରେ ଆପଣଙ୍କ biology ରେ ଅଛି ଟ୍ରକ୍ ଓନର ମାନେ ହେବେ, ଟ୍ରକ୍ ହେବେ ନା ଓନର ମାନେ ହେବେ?
ଟ୍ରକ୍ ଓନର ମାନେ members ହେବେ।
ଓନର ମାନେ ହେବେ।
ଓନର ମାନେ ହେବେ। ଟ୍ରକ୍
ଆପଣଙ୍କର କନଫ୍ୟୁଜନ ହେଲା ଯେ ବର୍ତ୍ତମାନ ଆପଣ ଗୋଟେ ଟ୍ରେଡ୍ ୟୁନିୟନ କଲେ as ଟ୍ରକ୍ ଓନର୍ସ। ସେଥିରେ ଆପଣ ମାନେ ଯଦି ମେମ୍ବର ଅଛନ୍ତି ଟ୍ରକ୍ ତା କେମିତି ରହିବେ?
ଟ୍ରକ୍ ମୁଁ କହିବା I am just becoming a member of a trade union.
ଆପଣଙ୍କର it is rather ମୁଁ କେବେ ଯେତିକି whatever I have read the little bit of labor law, first I am seeing that any employer is forming, though it is possibly you are employer of certain driver, cleaner and other loader, everything. You have formed a trade union where your truck is to be registered.
No, that,
You are absolutely.
I think I'm leading wrong.
Can you argue? Just go on replaying the YouTube. So
I think I'm leading.
So when you are saying that I've been misunderstood,
No,
I'm not making my point. Leave it there. We have spent sufficient time in whether a truck or truck,
Lordship,
whether a trade union should have trucks as its member or not. We have spent sufficient.
Lordship, Lordship, my only point, Lordship.
If so advised, other provisions of law. As a last submission, the petitioner learned counsel for the petitioner wants adjournment, which is granted reluctantly. The matter shall be listed for fresh admission in the week commencing 20/7/2026. At least have some discussion with the client before you make a point, and don't try to discover when you are saying that Annexure 9 is the answer to Annexure 8. And when you are asked why Annexure 9 refers to Annexure 8, then you say that I apologize. Why should you apologize? Never be apologetic.
Documentary proof भी किसी produce करना है, सिर्फ लिख दीजिए से. Neither he has only submission there, not any documentary proof.
I am powerful. Truck रो दाम पे तो जानते हैं, 300 लोग को ही चलते. तो सही तरह रीड पिटिशन रो क्वालिटी है हबो. Luxurious litigation. Sir, trade union फॉर्म कर देलेंगे. गोटे 10 टकिया ट्रक रो दाम कितने मु कहि परिनी, I do not know you. कौन टेस्ट theory जदि नेट वर्थ भावन्तु गोटे ट्रेड यूनियन रो टेस्ट theory टाइप गुणी देबे गोटे गोटे ट्रक रे इट कम्स टू सम थाउजेंड ऑफ crores. Anyway, you have done your part, that's it. Yes.
Item 16,
May I please, your lordship?
Pratibha Naik, CDC for.
Item 16 and 17, present arrangement.
For with the DSJ for the appellate. The office note indicates that the matter is listed for orders. Stop. Office note indicates that the valuation of appeal and court fee payable not correctly furnished. Hence, SR not made. In the meantime, court fee of ₹1830 has been paid. The Lord CGC shall take steps for furnishing the valuation of appeal as well as court fee payable by approaching the registry. कितने दिन समय कितने दिन?
1 month.
1 month. 16 मसीहार केस आगे.
Lordship, first time
we are celebrating the decade of an appeal.
May 2 weeks.
सीधे ताबिदर अपन ट्रक ओनर पोसिले सीधे पड़ेगा 15 मिनट. ट्रक ओनर को ट्रेड यूनियन ने की मेंबर हो.
Lordship, same item 3-8 को अच्छे.
3-8 को रखचन दे
same item से.
इंडिया मु फर्स्ट टाइम मते लागै छी एटा फर्स्ट टाइम आछ. As prayed for the Lord Council for the Lord CGC 6 for the 4 weeks time, which is reluctantly granted as the matter is cleared pending since 2016. 17 there is same order.
Listen.
The name of the Lord DSJ who was appearing earlier shall be deleted from the case brief as well as the first list. Record ये DSJ appear करिवे थ्री.
नहीं, only प्रतिमा नायक CGC.
Yes. कौन जोड़ा 3-4 सप्ताह टाइम लो ना थी आगे चेष्टा करो तो
फर्स्ट टाइम
ऑपरेटिंग बोल तो गोटे सप्ताह रे काम करिवे.
लॉर्डशिप बेटा फर्स्ट टाइम आछि टी फाइल.
ठीक है. Yes. 3-8 कोच जो मैडम. List in the week commencing 3-8.
17,
17%. 16-17 bola.
18,
16-17 same. Appearance same orders.
On behalf of Expeditious, pray for adjournment.
Again, sir, upon defective adjournment कौन? अपन को ना कौन sir?
Santun Kumar Behera.
Mr. S. Behera on behalf of S.K. Trivedi for the petitioner, the Lord Council for the petitioner 6 for the time to remove the defects as pointed by the SR. As prayed for further to the defects shall be removed within 10 working days. The matter shall be listed for orders in the week commencing.
19,
May I please, your lordship?
Yes, sir.
On behalf of my learned senior, I am representing item number 19, sir.
Yes, sir.
So in this case, the nomenclature is to be changed from RPFAM to CRLMP.
Has to be changed.
Sir?
Has to be changed.
Yes, sir.
Yes.
Sir, as we are praying for the quashing and set aside the impugned order dated 3/5/2021 passed by the learned judge family court Khordha in CRP number 342/2018 for the greater interest of justice, sir.
What sir can do in
Sir,
changing the nomenclature? Sir can do nothing.
Sir, we have to file an IS.
Of course. Now, after all this discussion, the last 2 lines are important. You have not filed the IA. Sit for time. The matter was presented before this court in the year 2000 on Ete. 22/3/2022. Since then, it is kept pending. after the stamp report dated 25/22 indicated that से भी स्टाम्प रिपोर्ट जहाँ लिखिछंती ताकू के पढ़ियो बा आपण पढ़ी पड़छंती ई कोन ई पर कोन रिटायर्ड करले ना कोन पर से सेट पर रिटायर करियो रे भलो होय कोन लिखले indicated that correct nomenclature may be CRL NP.
My lord.
After 4 years, adjournment is sought for by the learned counsel for the petitioner seeking further time. It is instruction not here. Upon sir, both busy loco. See, case space of the Kiven.
Sir, one.
4 years Hegalani, defective vehicle Roila. On Lekile. Learned counsel for the learned counsel appearing on behalf of the learned counsel for the petitioner. This is the senior case. Upon Kibe join Kale.
Sir, recently joined.
Upon 4 years senior. On Lekile. So accordingly, for the accordingly it is directed the defects the IAB filed within 10 days. The matter shall be listed for orders in the week commencing. Ither kitchen nothibo Mr. Mahanti.
Hello.
Ite kon ache?
We have to file the nomenclature in this case.
Aଜ୍ଞା କରିବେ ଯେ ସେଟା 22 25 ଦିନ 22 ରୁ ଏ ପର୍ଯ୍ୟନ୍ତ ହେଇନି ଆଉ କଣ ହବ?
My lord.
ଏ କେସ୍ ଆଉ ସାର୍ କରିବେନି.
I'll take the first step.
Difference ହେଲା ସେ ସାର୍ କହୁଥିଲେ ଆପଣ ମାଇ ଲର୍ଡ କହୁଛନ୍ତି. ଆଉ କିଛି ଡିଫରେନ୍ସ ନାହିଁ. କଣ ଲେଖିଲେ? The week commencing 27 26. I'm sorry 26. नहीं मोर भी भूल भाल है आप सारे पढ़ी मोर भी गलत 27 ठीक है 27 26 इधर इंस्ट्रक्शन नहीं होते इधर किससे क्लाइंट आसुनांती और करिवे नहीं सर करिवे
I will take the instruction.
टेप पे जो डिफेक्ट रिमूवल है ठीक है
Item 20.
Obligation.
यस प्लीज मिस्टर आपण आई एम सॉरी आपण नाटा मु पचारथिली
Vishal Samant.
विशाल सामंतराय BISH Vishal Samantray on behalf of Vishal Samantray and Mr. A. Mahanti on behalf of Prabhas Chandra Jena for the petition. Yes, next.
Item 20.
On behalf of Mr. Palo, my lord.
Yes.
Let this matter next to it, my lord. Due to some of the.
Sir, you are Mr. Swain.
No, I am Gauri Kumar Rath.
I'm so sorry, Mr. But Gauri Kumar Rath on behalf of Ramanath Palo for the petitioner. ये भी सर इतने पुराना केस अपन
My lord, due to some of the personal difficulties, Mr. Palo is not in station. That's why. Any day next week.
अपन तो बर्तन the challenge to any order of maintenance man तो difficulty होची कुछ असुविधा
No, my lord, execution is there. He is paying the
execution के जे को करू ना से 4 वर्ष रे पिला कोन execution करिवो
No, mother is there. Mother and yeah,
से कि जे बुझुची
husband is paying regularly.
कथा भी पिला कोन बुझी परिवो execution करिवो ठीक अछि
No, mother
adjournment is sought for though the matter is pending since 2023. It has not been listed. Today being listed, no, it has not been listed. Stop. Today being listed for orders, the lauded adjournment is sought for on behalf of the lauded counsel for the petitioner to grant further opportunity. The matter shall be listed in the week commencing.
Next week.
27-26. If you say have a client asunandi or kahi
No, my lord. No, my lord. Though I am conducting other cases of this client, that's why Mr. Palo said that kindly go.
See, upon all pauchandi.
No, not.
से पे डर की पालो आसुना से आसी आपण को पारिबेनी ठीक अछि आइटम 21
Item 21.
Deposit court fee sir दोना दी
that is due to financial stringency the appellant is a old man, is about 70 years. He was having some land. The land in question was taken over by the project.
Just check how what is the amount he has received.
You also that is reflected in the judgment. Yes.
So he has received that amount without prejudice. From that amount, how much? What is the amount?
Yes, you'll also see at last para. A meager amount compensation was paid.
Hey, what is the amount?
Yes, yes, ma'am. Yes. 92,000 towards Mal Kisam land and 1,50,000 towards Bahal Kisam land.
So total 2 lakhs?
No, they have, Your Lordship, see, the applicant lost land to the extent of only. Yes, yes. Ma'am.
ଲକ୍ଷେ 52,92,000 ହେଲେ ହଉଛି
Total 6 acre 44 decimal ଯାଇଛି.
କେତେ ହେଇଗଲା ତାହେଲେ?
Yes.
6 acres କେତେ ହେଲା? You are a landlord, I know. So 6 acres କୁ କେତେ ହେଲା ପାଖାପାଖି? 2 ଲକ୍ଷ ହେଲେ ହେଲା 12 ଲକ୍ଷ. So 12 ଲକ୍ଷ ସେପଟେ ଆହୁରି ପାଇଥିବେ
Additional market value.
ହଁ କେତେ? So after you have received 20 lakhs, financial stringency has arisen and you have not paid rupees 18,000.
No, the same was not
ଯଦି
received.
order ଲେଖିବି ଆପଣ ଭାବନ୍ତୁ, you must understand what I am writing.
On that.
20 ଲକ୍ଷ ଟଙ୍କା ପାଇଲା ପରେ
No, in fact,
financial stringency ହେଇଗଲା ଆପଣ ଆଉ 19,000
award was not received.
Eh?
Award was not received till late.
there is no disputed ଆପଣ enhancement file
Your Lordship, see, enhancement file is sir.
ଆପଣ ସେଟା
Because same kisam of land, Your Lordship, see,
interstate dispute ରେ
yeah.
interstate dispute ରେ receive କରି ପାରିବେନି.
Your Lordship, see at page,
ଆପଣ ଖାଲି lordship सी କହିଲେ
sir, same kisam of land ko apan ko
the petitioner seeks for the matter is listed for appeal. The appeal is listed for orders LAA 34. As the deficit court fee of rupees 18,722 of .2.25 18,722 टका 25 पैसा has not been paid. The petitioner has already the learned counsel for the petitioner shall obtain instruction. Petitioner no, appellant shall obtain instruction how much amount the appellant has received as compensation till date. The matter shall be listed for orders in the week commencing. Sir, 27.
last week,
even
last week, I think.
Satish sir.
Maybe that,
Again?
or else some time is granted so that I'll take. Your Lordship, keep it on 20th, sir. Last week is July.
Satish sir ରହିଲା ପରା?
Aye.
ଆଉ ତ 30 ପରେ ତ ଡେଟ୍ ହିଁ ନାହିଁ। ଆଉ ଲାଷ୍ଟ ଆଉଟ ଆଉ ଲାଷ୍ଟ କଣ ହେଇପାରିବ? ଜୁଲାଇ ସରି ଯାଉଛି 31 ତାରିଖରେ। ଆପଣ ତା ଭିତରେ 18,000 ଟଙ୍କା ଦେଇ ଦିଅନ୍ତୁ। ତାଙ୍କୁ ଡାକନ୍ତୁ।
I'll text it. I will intimate the trial court advocate and.
ଯେତେ ପାଇ ଯାଉଛନ୍ତି ସେତେ stringency ବଢି ଯାଉଛି। ବୁଝିପାରୁଛନ୍ତି ତ?
Item 22,
Lord, we have 5 memo for withdrawal.
Kindly give that. Miss Chakravarti.
Chatterjee.
Miss D. Chatterjee.
Rituparna Chatterjee.
Rituparna, I'm sorry. Miss Rituparna Chatterjee on behalf of Amit Prasad Bose for the petitioner. Opposite party ke nahanti nahi ki? Opposite party none.
I am standing for the opposite party, sir.
Mr. Chittaranjan Sanbad,
Again.
the opposite party. Learned counsel for the opposite party being present at the virtual court, High Court of Orissa at Sambalpur, addresses arguments.
Sir.
Sir, upon Sambalpur ଅଛନ୍ତି ତ ମତେ actually ଜଣା ପଡୁନି।
Yeah. Sambalpur virtual court, sir. This.
ସେଠି କଣ ଯାଉ ମାନେ ଆଉ ଗୋଟେ ଚେମ୍ବର ଖୋଲିଲେ ବୋଧେ ଭିଡ ହେଲା ବୋଲି।
ନାଇଁ sir, ପୂର୍ବରୁ ଅଛି sir ଦିଟା।
ସେଇ ଦିଟା ଯାକ ଅଛି।
ଆଜ୍ଞା।
Memo.
Sir, ଏଥିରେ already settle ହେଇଛି sir ଆଉ
ସେ withdraw କରୁଛନ୍ତି sir. Withdraw
ଆଜ୍ଞା। I agree.
ସେ ସର୍ଭ କରିନାହାନ୍ତି। Memo dated 23/6/2026 has been filed by the learned counsel for the petitioner upon instruction, which states thus. ସେ ଲେଖିଛନ୍ତି actually mention memo ଟା ଫାଇଲ କରିଦେଇଛନ୍ତି in the aforesaid case to ନେଇକି interest of justice. The memo is available on record. The learned counsel for the opposite party is being present, has no objection for the petition being withdrawn. Accordingly, the petition stands disposed of.
23.
My lord, I am in VC. My lord, I am in pardon, my lord. The matter has been listed.
For the petitioner, Mr. Devendra Narayan Patnaik for the opposite party. Yes, sir.
Matter has been listed for a condonation for delay, my lord, on orders, my lord. That is delay of 180 days OP has already appeared, no objection filed. Maybe I may object orally. Delay may be condoned. But
Delay would not be condoned unless you pay the amount.
amount Miller?
Kete total amount due kete achi?
Due the execution dues, they are we are paying Miller in court below Miller.
No, my lord. 1,60,000 near about.
Kete?
1,60,000 near about.
No. File affidavit. File affidavit.
ଆପଣ କରିବେ ନା ନିଶ୍ଚିନ୍ତ
No, ଆପଣ ଯଦି ଆମେ ଆମେ ତ payment execution they are getting payment in execution. Each and every steps. They are not. They may file an objection.
ଆପଣ ହଉଛନ୍ତି petitioner opposite party affidavit file କରିବେ.
Then they have to file objection with affidavit saying outstanding. Then I will pay.
Dismissed.
My lord.
On this submission, I am dismissing the RPFA.
No, what is the manner? They are saying, I am saying that I am paying in execution. Execution continuing, and they are not filing an objection.
I don't know. You are saying, but you are saying, and they will file affidavit that you are saying.
They have to file affidavit with objection, my lord. They are not filing an objection.
If there is affidavit, debe diontu, nole dismiss hontu.
ମୁଁ ବି affidavit ଦେବି ସେ ବି affidavit objection ଦିଅନ୍ତୁ ଦି ଜଣ affidavit
objection ଦେବେନି ଆପଣ amount ଯୋଉଟା କହୁଛନ୍ତି affidavit file କରିବେ
ତାପରେ my submission ମୁଁ ଦେବି ଆପଣ
I can also laugh like you. No difficulty. It is not a laughing competition.
No, my lord.
The proposition is absolutely laughable.
My lord.
You are asked that whether you are paying, that I am paying in execution.
Execution procedure continuing.
Says that you are like 20, then you are saying you file affidavit.
ସେ dispute କରୁଛନ୍ତି ତ objection ଦଉନାହାନ୍ତି ଆମ କଣ କହିପାରିବି
କରୁନାହାନ୍ତି କୋର୍ଟ ଆପଣଙ୍କୁ ପଚାରୁଛନ୍ତି ସାର୍
ଆଜ୍ଞା କୁହନ୍ତୁ ସାର୍
don't try to act so smart. You are smart, but that you can't be that smart that they will file affidavit whether you are paying it or not, and you are challenging it.
Then that's true. I will file affidavit regarding payment and outstanding. They should also file an account objection with all the details.
Seta judgment order ta apan chhadi diyontu. Court ko chhadi diyontu. You are tempted to pass orders and judgment seta karuntu.
Obliged.
I am also really obliged that you have realized that.
No.
The petitioner before this court is the husband in the marriage.
No, husband have dispute no, my lord. It is dispute between father and son. And father is a government retired government employee and getting pension. A payment is not so emergent, my lord. That
all
is
the payments have been taken by the sons from the father.
No. That is different things. There is a retired government employee getting pension of 28,000.
Is the father of the opposite parties. He challenges the judgment dated 162024.
Father of the man lord. Opposite party is the father. Court below petitioner, father was a petitioner. These present petitioners are sons.
The petitioners are the sons of the opposite party. They challenge the judgment and order dated 162024 passed by the learned judge family court Khurda in CRL.P. number 120 of 2023. Wherein the learned court has directed the payment of rupees 1,000 by each of the sons to their father. $1,000 from the petitioner.
1 and 3.
1 and 3 and 2,000 from OP number, the petition number 2 to their father as monthly maintenance. The petitioner was filed by the opposite party father under section 125 of CRPC seeking monthly maintenance, alleging negligence, alleging neglect.
Type of mistake maybe. Type of capital mistake. Negligence and
alleging neglect at thick English.
Again.
Alleging neglect on part of the sons towards the father. In view of the judgment of the Honorable Apex Court in Rajneesh versus Neha, that the amount directed to be paid as maintenance is akin to a money decree. The petitioners shall file affidavit indicating, giving the details. In brief, the date of payment, amount paid, and the mode of payment. After the judgment was passed by the Learned Judge Family Court. It is submitted by the Learned Counsel for the petitioner that the petitioners have been paying as the opposite party father has lost execution, has initiated execution for enforcement of the direction for payment of monthly maintenance. The petitioner shall also indicate the amount that has been paid in the pending execution application. The affidavit shall be filed by
within 7 days.
By 13/7/2026 upon serving copy thereof on the Learned Counsel for the opposite party. Yes.
Well, till 10 minutes, DW, NBW is there, it may be stay till 10, that minute. Till 13.
ସେଠି ଦେଲା ପରେ MBW ବଳେ ହେଇଯିବ
My lord,
ଆପଣ ପଇସା ଦେଲା ପରେ MBW ହେଇଯିବ
ଦି ତିନିଟା ଖଣ୍ଡେ ଏକ୍ଜିକ୍ୟୁସନ ଫାଇଲ କରିଛନ୍ତି କୋର୍ଟରେ ଦିଆ ହେଇଛି କୋର୍ଟରେ ରିସେଣ୍ଟରେ
3000 ଟଙ୍କା 2000 ଟଙ୍କା 1000 ଟଙ୍କା ଲେଖାଏଁ ଦେବେ ନହେଲେ MBW ଦେବେ problem ଶୁଣନ୍ତୁ Mr. Das Mahapatra, you should don't make a strategic blunder because I will direct if the amount is paid the NBW shall be stayed. Conditional that will be abel mujhe maar.
That is automatic.
Trial court adjourn କରିବେନି ଆପଣଙ୍କୁ ଭିତରକୁ ପଠେଇ ଦେବେ.
That is automatic. ମୁଁ affidavit file କରିବି ଥାଉ ଦେଖ ଠିକ ଅଛି. ଏଥିରେ ହଉଛି ସେ pension holder and married for third times are living separately due to
you also keep marrying.
My lord,
you all of you also keep marrying.
First time, second time, third time, that is the dispute between the family millets caused by the father. That not otherwise for 1000 rupees.
ସେଇଥିପାଇଁ 1000 ଟଙ୍କା ସେଇଥିପାଇଁ ଆଜ୍ଞା 1000 ଟଙ୍କା ଆପଣଙ୍କୁ କହିଛନ୍ତି ନହେଲେ ତ 10000 କହିଥାନ୍ତେ.
ହଁ ସେଇଥିପାଇଁ କୋର୍ଟ ହାତ କନସିଡର
ଆପଣ ଗୋଟେ ଆମାଉଣ୍ଟ ଟାକୁ ଏଠି ଧ୍ୟାନ ଦିଅନ୍ତୁ 1000 ଟଙ୍କା ଆପଣ ବାପାଙ୍କୁ ଦେବେ ସେ ପରେ ସେ ଏକ୍ସିକ୍ୟୁସନ ଫାଇଲ କରିବେ DN ପଟ୍ଟନାୟକକୁ ଏନଗେଜ କରିବେ ଆପଣଙ୍କୁ ଏନଗେଜ କରୁଛନ୍ତି ପୁଅ ମାନେ 3000 ଟଙ୍କା ପାଇଁ.
ଗୋଟେ family dispute.
For the competition, you want to match your father in marrying, you go and keep on marrying. Yes, 24. Odisha. Kuda kile? Mahapatra sir karo. Odisha. 13/7 affidavit दियंतु 20/7. ना early चाहुଛନ୍ତି Mr. Mahapatra, Das Mahapatra.
ठीक early चाहुଛି.
अच्छा ताले affidavit by 6/7 list in the week commencing 13/7.
Obliged.
24.
Non-appeals for the petitioner when the matter is called to grant further opportunity. Listing the week commencing 27.
25.
Your name, madam? N. Mukhi. Miss N. Mukhi for the petitioner. What is the case, madam? Have you read it? Don't always develop because today I'm marking actually many of you have started reading. You make a statement looking at the court in a very brief statement. Your case is rather easy because you have to say that the wife seeks enhancement of monthly maintenance. That much you have to say. The petitioner before this court is the hard-learned counsel for the petitioner. The petitioner before this court is the wife in the marriage. She seeks enhancement of the monthly maintenance granted by the Learned Judge Family Court Rourkela in criminal proceeding number 46 of 2022 by judgment dated 4/12/2024. it is submitted that the maintenance, upon kete magitile kete? It is submitted that though the petitioner had sought for monthly maintenance at the rate of rupees 45,000, the learned judge family court has awarded maintenance at the rate of rupees 10,000 per month, which is like one husband, wife. Sentence account. ସେ ଆପଣଙ୍କର ପ୍ଲୁରାଲ ସେଟା ମେନସନ କରିଦେବେ ଆରମ୍ଭ ଲେଖ ଆରମ୍ଭରୁ ପଢ ସେଟା petitioners କରିଦିଅ. The petitioners before this court are the wife in the marriage and the minor child born from the wedlock. Scene of it they କରିଦିଅ, they challenge. तापर लास्ट लाइन टा पढନ୍ତୁ. हाँ 10,000 for the 10,000 per month for the wife and rupees 20,000 for the minor child towards maintenance and educational expenses from the date of application that is 15/7/2022. By filing the present application, the petitioner seek enhancement. Issue notice along with this order. So notice to opposite party requisites for issuance of notice by speed post with heading. You declare issue notice. Issue notice in the IA as well as the petition along with this order. The Purpur line to insert korantu. The petition has been filed after a reported delay of 10 days. Then issue notice. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days or 3 working days. 5 working days. Returnable date be fixed to. तीन आठ the matter shall be listed in the week commencing 10/8 ଆପଣ 3/8 ଟା କଣ listing date ନା
return
3/8 5/8 କରୁଛନ୍ତି ଠିକ ଅଛି 3/8 week commencing 10/8 ଆଇଏଟା କଣ ଫାଇଲ କରୁଛନ୍ତି limitation ଟା ଠିକ ଅଛି in the it is further directed that the petitioners shall continue to receive the amount as directed by the learned judge family court without prejudice to their rights and contentions in the present application. Always read whatever ଆପଣ ଯେତିକି ବି ବୁଝି ପାରୁଛନ୍ତି ପଢନ୍ତୁ. Spend time with the brief. ଆପଣ brief ଟା କେତେବେଳେ ପାଇଲେ? ସକାଳେ ହେଲେ ହବନି. ସକାଳେ ହେଲେ ବି ଆପଣ ପଢିବା ଅଭ୍ୟାସ କରିବେ କମ ସମୟରେ ନହେଲେ ଇଭିନିଂ ରେ ପଢିବେ. So that you get acquainted with the provision, all these things. Everyone starts like that. Yes.
25, 26.
So BP Pradhan for the petitioner.
But 88 days delay in preparing the present decision. I have challenged the order of maintenance under Annex 3 at page 28.
Yes.
3,000 has been awarded per month. I have taken the ground milled after decree of divorce. Now wife has already married second time. So she is not entitled.
No, this is 24 or 125 maintenance?
125 maintenance. After decree of divorce, you filed a separate 125.
We do take that stand in the petition.
Yes, I have mentioned that. That is the sole ground I have taken para one.
Before the trial court, what is the stand?
trial court has judgment से जिनसे नहीं. I have seen that.
देखियो पड़िबो नहले
No, there is no nahi. I have seen.
No. When
The pleadings were there or not,
yes.
that I have not checked up.
Because
I have not.
that
Only-
would be the weakest point in the case.
Yes, correct, madam. Because they have supplied only impugned judgment. That's why I have gone through the impugned judgment, adapted my petition on the basis of that. This is the only stand available with me.
ଆପଣଙ୍କର stand was different.
Judgment again different second jehetu mutual. Yes, this is a mutual decree of divorce.
OP1 admitted in cross-examination that he has not paid any monetary assistance to the petitioner since her date of separation and after passing of the decree of divorce in her favor.
Yes.
He was ready to keep petitioner with him prior to divorce and now he is also ready for the same. So
That ground has-
so this is apparently a new stand.
Yes.
ଆପଣ କେତେ ଟଙ୍କା ହେଇଛି
3,000.
3000 କେତେ ଦିନ ହେଲାଣି
এটা তো হিচি অর্ডার ওয়াজ পাসড অন 9/4/2020
ପାଇସି ହେଲେ ଆପଣଙ୍କର 3 ବର୍ଷ 36 ମାସ 3 ବର୍ଷ ହେଲେ 3000 ହେଲେ 1,08,000 ତାଙ୍କୁ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣନ୍ତୁ କେତେ ପଇସା ସେ ଡିପୋଜିଟ୍ କରନ୍ତୁ.
Yes, correct.
by what time?
Let's not fix up any date. I'll obtain instruction and file an affidavit.
Hard loaded counsel for the petitioner. The petitioner ଆପଣଙ୍କ divorce କଣ grant ହେଇଛି in a CP?
Yes, under Annexure 1.
Filed by the wife.
Husband. There are contesting decree of divorce.
Husband wife file କରିଛନ୍ତି. Prabhasini versus Rajendra.
Sorry, ma'am. Excuse me.
କଣ ଲେଖିଲ? Petitioner is the husband in the marriage. Petitioner, husband in the marriage challenges the judgment dated 9/4/2024 passed by the Learned Judge Family Court Puri in CRP number 102 of 2022. The said by the said CRP was filed by the wife in the marriage. Seeking monthly wife in the marriage on 1/12/2022 seeking monthly maintenance at the rate of
20,000, but our
20,000 per month. Under the provisions of section 125 of the CRPC. Into bracket since repealed and substituted by perimeter Purana complete.
Sorry, madam. Claiming 15,000 or
15,000. Claiming 15,000. କେତେ ଆପଣଙ୍କୁ ମୁଁ କେତେ ଡାକିଲି 15,000 15,000. The CP number 17 of 2021. No, CP number 17 of 2021 filed by the opposite party wife under section 13 of the Hindu Marriage Act has been decreed by grant of decree of divorce dated 22/10/2022. Is submitted by the Learned Counsel for the petitioner that but in anyhow this is your amount this has to be paid till she get married. Still she gets married for the second time.
Correct. That's why Lord dies.
It is submitted by the Learned Counsel for the petitioner that the petitioner shall file affidavit indicating how he will secure the amount as well as the amount, if any, that has been paid pursuant to the judgment and decree directing payment of maintenance. The affidavit shall be filed by 13/7. By 13/7. Earlier even 13/7. 13/7/2026. The matter shall be listed in the week commencing 37. 37/7. 37/2026. তাহলে 27 করবে affidavit by 27. Date 37. Yes, next.
27.
Already the deficit amount has been filed, ma'am. 56,230. On 15/4/2025.
ସେଟା କାହିଁ ଦେଖଉନି ତାହେଲେ 25 ମସିହାରୁ ଫାଇଲ କଲେଣି
Yes, in
Mr.
the,
Prem Kumar Mahanti, Additional Standing Counsel
in
for
the
the
note,
appellant.
order sheet it is written.
Mr. Naik, Nahantike, opposite party, respondent, none.
On behalf of Mr. Naik,
Yeah, acha, Mr. B. Das.
B. N. Sapati.
I'm sorry, Vichitra Satpathy on behalf of G.K. Naik for the
Appealing for 1 and 4.
respondent. Office note put up by the registry indicates that deficit court fee of rupees 56,233. 56,233 टंका 25 पैसा to be paid. The learned AC submits that the deficit court fee has been paid on
15/4/2025.
15/4/2025. The learned AC is requested to take steps for verifying the matter with the registry.
Right.
The registry shall do well to verify regarding payment of the deficit court fee as stated by the learned Additional Standing Counsel and put off the note accordingly. Put off office note accordingly. The matter shall be listed for orders. 2 weeks for 3 weeks for 27 27 27 रखो आपण 27 101 अछि the week commencing 27
28.
so Niranjan Lenka for the petitioner. Yes.
So the organ will challenge the order of maintenance.
Yes.
That is deduct 27.
Yes, but unless he makes the payment, a deposit shall not issue notice in the delay. That I have already pronounced. Because your submission is that first notice should be issued for delay, then. But I'll consider on merits. That I have already. In another matter, in your matter, actually I could not get your assistance, which I was expecting, because either way it can be decided. To start with, possibly it can be interpretation can be that delay first considered, then the merits. But there is sufficient material case law on this that it can, and of course CPC is there. Order 47-1-3, 3A. 3A is delay. 1-3 is that court will direct payment deposit securing of the decree. And it is a revision.
In the event of stay, then subject to payment.
3 stay ne. 3 stay ne. 10 re bhi achi. 10 और 3 re. The appellate court in its discretion either before the respondent is called upon to appear and answer or afterwards. On the application of the respondent, demand from the appellant security for the cost of the appeal or the original suit or the both. Where the appeal is against a decree for payment of money, the appellant shall within such time as the appellate court may allow deposit the amount disputed in the appeal or furnish such security in respect thereof as the court may think fit. But amended, but this amendment is very old actually, 1 to 1977. So relying on that, and there is one Supreme Court decision. Sure.
Now, things are not operated as a stay of proceeding under a decree.
Yes. See that in fact that is a facet of why the decree shall not be stayed.
Yes, subject to.
Then 3 comes before that. 1-3 is much before 5. Sub rule 3 rather. Order 41, rule 1, sub rule 3. Three capital A 3. 3A actually important, not 5. বইটা দিত না সেটা পড়িয়ে অসুবিধা হবে ছোট ছোট একটা সিট দিন আপনার পাখে আছে থ্রি ক্যাপিটাল এ দেখুন
fact on which the appeal will be made to satisfy sufficient cause for not preferring the appeal. If the court see no reject the application without issue of comment, if thereof shall be issued to the respondent, and the matter shall be finally decided by the court, for it proceed to deal with the appeal on the where an application.
So now 2 is important because whether the court has discretion to decide whether to issue notice or not. If I am condoning the delay, I may not issue notice in delay. Then 3 is important. Where an application has been made.
Under sub-rule 1, court shall not make an order for stay of execution of the decree against which the appeal is proceeded to be filed.
Proposed to be filed. Appeal is proposed to be filed, not proceeded.
If proposed to be filed, so long proposed to be filed, so long as the court does not, after hearing
Under rule
11, decide hear the appeal.
Yes. So there is absolute bar on the court. No stay can be granted. And 11 after amendment is still interesting. Can you look at 11? Power to dismiss appeal without sending notice to the lower court. So in that, in one matter I have referred to this. Of course, they are now, since you raised 3A I have not dealt with because 3A is more clear. 3A English 3A3 is clear that it shall not. ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣନ୍ତୁ ସେ ଯଦି ଦେବେ ଦେଖନ୍ତୁ କେତେ ସେ କଣ କହୁଛନ୍ତି appearance actually the petitioner before this court is the husband in the marriage. He challenges the judgment. 10-12 का order कर दो चुन सब बड़ा judgment dated 10-12-2025 passed by the learned judge family court Baripada in criminal proceeding number 5 of 2024. The said criminal proceeding was filed by the wife in the marriage under the provisions of section 1 under section 125 of CPC into bracket since it will bracket closed, claiming monthly maintenance at the rate of rupees 30,000. So the petition was favored, however, granting a monthly maintenance at the rate of rupees 4,000, which is under challenge. In view of the judgment, in view of the The learned counsel for the petitioner is appellant, the petitioner, appellant petitioner is apprised of the provisions contained in Order 41. Rule 1 into bracket 3. Rule 3 dash capital A into bracket 3, as well as rule 10 and 11. Stop. The Honorable Apex Court in Rajneesh versus Neha have held that the amount of maintenance directed to be paid under section 125 of CRPC is akin to a money decree. Accordingly, the petitioner shall file affidavit giving the details of payments he has made by giving a brief statement of date of payment, amount paid, mode of payment. Stop. The affidavit shall also indicate how the petitioner shall secure the amount for sustaining the challenge in revision before this court. The affidavit shall be filed by Kodi Sat. Again, 22nd. By 22/7/2026, the matter shall be listed in the week commencing 3/8/2026. By 27 next at 27/7/2026.
29.
Mr. Vichitra Narayan Satpathy for the petitioner. Yes.
Let's see if I file an IA for exemption of the payment of court fees.
Apanakara project opponent has been made a party.
Project of, yes.
It was the appellate. Mr. Satpathy for the appellant, Mr. Ansuman Sethi for the respondent. But if project opponent to party करना है. This is covered by direct decision of this court.
Collector, land action officer.
They are statutory authority. Project opponent होची अपनकर Paradip, Haridaspur Paradip.
Haridaspur Paradip project.
They are in fact the same litigant. I mean the same respondent.
Yes.
There are decisions. Few decisions by this bench.
Yes.
By my bench, by Justice K.R. Mahapatra. Then this division bench decisions are also there. We have simply followed that UPA Awas Evam Vikas Nigam. Constitution bench 93 Supreme Court.
Let's I have to.
So you have to.
Yes.
And in fact, after 10 years, in at least 10 or 15 land acquisition appeals, I have remanded because keeping the matter pending.
Yes, sir.
Because the railways will never agree for this. They will go to Supreme Court.
Yes, sir.
So then what the ultimate result is, the entire thing has to be redone.
Yes.
So it is better you should go to the referral court, hear the rail company, and then whatever may be the consequence. IA 101 of 2026, upon copy pouchy.
Yes, sir, got it, but the copy is not, the petition copy is not legible.
What a ball copy would have to. The IA has been filed for exemption of court fee. It is submitted by the London Additional Standing Council that the copies are not very legible and he may be provided with legible copies of the petition. The London Council for the appellant shall provide. Appeal memo be bhalo nahi na kon ko. The London Council for the appellant shall provide legible copies of the IA to the London AEC within 3 days, 5 days.
5 days, 5 working days.
Within 5 working days. The London Council for the petitioner is apprised of the decision of the Honorable Apex Court Constitution Bench in UP Awas Evam Vikas Nigam, wherein it has been laid down that it has been held that in case of in cases where enhancement is sought for the project proponent, that is the Indian Railways oblique Haridaspur Paradip Rail Company, the project proponent, have to be made parties and heard by the referral court. In the case at hand, as is apparent, before the Civil Judge Senior Division, Ujanga, in the district of Jagatsinghpur, in CS number E dash E C कौन लिखा है जिसे?
It's a bit,
47 dash 2017 into bracket 52 dash 2017. That is a reference under section 18.
So let's see, that is LAR number 13/2018. So far the CS is concerned, so it is
Before the adjudicating authorities oblique courts, prior to filing of the present appeal, the project proponent has not been made a party. The learned counsel for the petitioner shall take steps for including the project proponent as party before in the present appeal. Stop. The learned additional standing counsel shall obtain instruction in response to the IA filed seeking exemption of payment of court fee. The matter shall be listed for orders in the week commencing 3/8.
mobilized.
তারপরে 30 সেম পারাদীপ হরিদাসপুর
Yes, yes.
ঠিক আছে 30 তার সেম
Lordship legible copy as well.
same one. He will provide.
31.
Mr. Srijit Mahanti for the petitioner. Yes, Mr. Mahanti.
Blood. This is enhancement of compensation that is under challenge, market value. So in this case and the other cases, it is based on an earlier decision of the learned reference court. That earlier decision is in challenge before this court. It is pending. So except for the second matter, the all other matters are based directly or indirectly on the earlier award, which is pending challenge before this court. That is the main ground, and the second ground is that the learned reference court could have applied that decision provided the similarities in the character and potentiality of both the lands had been established.
And the court did not go into that.
Court did not go into that. Court proceeded on the basis that since in that case and in these batch of cases, the same notification, same village, to maintain parity, a uniform rate was fixed. So that is the subject matter.
So what is the order passed in the similar matters?
My lord, same, it has been enhanced.
Copy. I mean, these are that tank. What is that storage?
Pump house of the Paradip, Raipur. My lord, I have not bought
I think
the.
You are not appearing in that matter. I had some matters.
Yes, my lord. I was there. Those were also fresh where notices have gone. The
similar order, if you can provide, or you can provide the order where the original that referral order has been challenged in while it is pending.
Look, that averment has been taken and that referral order is also annexed.
Party for the appellate. Opposite party blank. The
delay is there in all these matters.
Delay, I'll take notice in court.
Yes, Miller.
IA 126 of 2026 along with LAA. Mr. Ansuman Sethi, additional standing counsel for the respondent number 2. One blank रहेगा, that fresh matter. That fresh note, that order.
Some would have fresh also.
अच्छा. Fresh order से ऐसे delay पे.
Okay. So delay. My lord, we brief कर दीजिए date. Delay का cases to assist my lords.
Thank you.
So in all these cases, it is not
the
really as per
counsel for the appellant. It is submitted that the first matter re apna kuchuni rely kochane arata.
I guess first matter rely korichunti.
The learned refer the court. It is you Lara court na kon.
My lord, first matter na eta hauchi civil senior civil judge.
The learned referral court, that is learned senior civil judge. The referral court, that is Learned Senior Civil Judge Sambalpur in LA case number 3 of 2013, filed by the land oustee in a reference under section 18 of the Land Acquisition Act, has allowed the reference by enhancing the amount of compensation. Stop. For directing the enhancement of compensation, the learned court has relied on.
My lord, may I interrupt?
Please.
My lord, in this first case, they have relied upon the order passed in the third sub-item.
সেটা কোসে পারাকো স্টেট পড়াতো जो ফার্স্ট কেস রে जो से रिलाय করছেন সেটা has relied on the
My lord, para 6 at page 31 of the brief.
Relied on the judgment passed in LA case number 09/13 dated 1/3/2025, filed by one Anupama Pradhan. He submitted that the judgment dated 1/3/2025 in LA number 9 of 2013 into colon deki by bracket Anupama Pradhan versus so and so. Anupama Pradhan versus Special LAO has been challenged
Again.
by filing
this
number. Anupama Pradhan number
57.
LA 57 of 2026, which is listed along with the present matter. So, he submitted that for determining the enhanced compensation, the learned court though has relied upon the earlier judgment, but has not gone into the similarities and prospects of what is that?
The characteristic and potential of the land.
Characteristic
And potentialities of the land.
Characteristic and potentiality of the land which was acquired from the opposite party. And our respondent from the respondent. R1. Stop. Issue notice to the respondents. Issue notice along with this order. Stop. The learned additional standing counsel upon advance copy served appears and waives notice on behalf of R2. Notice be issued to the R1 by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 5 working days.
Yes, please.
Returnable date be fixed to 3/8/2026. The matter shall be listed in the week commencing 10/8/2026. Stop. आइए रे कौन एग्जीक्यूशन ହେଇଛି
नहीं एग्जीक्यूशन है ही नहीं
नोटिस नहीं होता ताले
आइए रे नोटिस
आइए
Substantial-
counsel for the appellant petitioner he reiterates his submissions as noted above issue notice as above accept one set of process fee as well as postal requisites ଆପଣ ବ୍ୟାଚ୍ କରି କାଇଁ ଲିଷ୍ଟ କରୁଛନ୍ତି ସବୁ ଯାକ ଅଲଗା ଅଲଗା କେସ୍
मतलब सबू
I am just asking my court master. ଆପଣ ଯୋଉ ମତେ 32ଟା କହୁଛନ୍ତି ଦେଖିଲା ବେଳକୁ ଲିଷ୍ଟ କରୁଛନ୍ତି 40ଟା. Anyway. Only. Yes, the returnable date as well as the next date of listing will be as directed above. In the interim, there shall be stay of the impugned award.
डिले कंडोन डिले अछि तणु may not be fair.
प्रॉब्लम हो जे फिर आपण मेंशन कर आगे हे गला
My lord, I will take that chance, but it would not be fair to press for
तो तापरे
no prayer भी नहीं मैं
yes
ये नहीं my lord duinum that
ଆପଣଙ୍କର ଖାଲି ଯୋଟା ଗୋଟେ ଅନୁପମା ପ୍ରଧାନ ଅଛି LAA 56
57 Anupama Pradhan
57 ରେ ସେ ଲାଇନ୍ ଟା ରହିବନି ଅନୁପମ ପ୍ରଧାନ ଲାଇନ୍
57,
ବାକିଟା ସବୁ ରହିବ ସେ ସମରି କରିକି ଦେଇ ଦେଇଛନ୍ତି
my lord, 56 is different. 56 is different. Second item.
different ମାନେ
Different manner, they have not referred to any earlier award. So it has been enhanced on
56 ରେ
the,
ଅନୁପମ ଲାଇନ୍ ଟା ବି ରହିବନି
based on the potentiality.
ଖାସ୍ ଟା କରିଦିଅନ୍ତୁ ତାପରେ just ଖାଲି ମାର୍କ କରିଦେଇଥାନ୍ତୁ 56 no ଅନୁପମା 57 no ଅନୁପମା 58 59 60 61 ଅନୁପମା
Anupama, 15 of 2012. Anupama, my lord, if takes Anupama, the third sub item. So my lord will find there is a reference to.
ନାଇଁ ନାଇଁ ସେଟା ଛାଡି ଦିଅନ୍ତୁ ତାହେଲେ ଠିକ ଅଛି
Aye.
ସେଟା ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ନା ନାଇଁ
Seta challenge is Seta first case 15 of 12, that is challenged in 15 of 22. That is the base case.
ଆପଣ ଗୋଟେ କଲା ପରେ ଜଜମେଣ୍ଟ ଦେଖିବାକୁ ଏଟା ଦେଇଦିଅ 31 32
I'm saying that 32. I'm appearing for the opposite party. I'm seeking a small adjournment, my lords.
so actually we have run out of time 32 paucity of time intervenes Mr. M. Pagal for the petitioner, Ms. Pratyusha Naidu for the opposite party. Paucity of time intervenes, the matter shall be listed for admission in the week commencing. 10/8 Mr. Pagal. 10/8 2026. Passover. এটা আপনাদের ঠিক কেয়ারফুলি করে আসুন। বড় ফাস্টটা কলা পরে। Yes.